Our dignitaries are about to arrive on the dais. I request you all to kindly maintain silence, keep your mobile phones on silent. Please be seated. A very good morning and Johar to this august gathering. On behalf of the Judicial Academy Jharkhand, it is my immense pleasure and proud privilege to extend my hearty welcome to our esteemed chief guest, Honorable Mrs. Justice Bangalore Venkataramaiah Nagaratna, Judge, Supreme Court of India, Honorable Mr. Justice Apresh Kumar Singh, Judge, High Court of Jharkhand, come Executive Chairperson Chalsa, Honorable Mr. Justice Sri Chandrasekhar, Judge, High Court of Jharkhand, come Judge in Charge, Judicial Academy Jharkhand, Honorable Mr. Justice Rangan Mukhopadhyay, Judge, High Court of Jharkhand, and Honorable Mr. Justice Kailash Prasad Dev, Judge, High Court of Jharkhand. I further extend my heartfelt welcome to Honorable Judges of High Court of Jharkhand, our exceptional speakers, esteemed guests, respected madams and participants to today's conference on women's right to property, road to empowerment, being held at Dr. APJ Abdul Kalam Auditorium, Judicial Academy Jharkhand, as a part of Golden Jubilee celebration of the establishment of the Circuit Bench of the High Court of Judicature at Patna in Ranchi. I now request Ms. Ranjana Asthana, Principal District and Sessions Judge, Bokaro, to honor our chief guest, my lady, Honorable Mrs. Justice B.B. Nagaratna, Judge, Supreme Court of India, with a bouquet. Thank you, ma'am. I request Mr. Mohammad Shakir, Registrar General, High Court of Jharkhand, to present a bouquet to my Lord, Honorable Mr. Justice Apresh Kumar Singh. Thank you, sir. I also request Mr. Nalin Kumar, Law Secretary, State of Jharkhand, to honor my Lord, Honorable Mr. Justice Sri Chandrasekhar, with a bouquet. Thank you, sir. I request Mr. Arun Kumar Rai, Judicial Commissioner Ranchi, to present a bouquet to my Lord, Honorable Mr. Justice Rangan Mukhopadhyay. Thank you, sir. I now request Mr. Sudhanshu Kumar Sashi, Director, Judicial Academy Jharkhand, to honor my Lord, Honorable Mr. Justice Kailash Prasad Dev. Thank you, sir. I now request our judicial officers to honor our distinguished resource persons, Honorable Judges of High Court of Jharkhand, Advocate General of Jharkhand, and former judges with bouquets. Thank you, sir. It is better to light one candle than curse the darkness. With this quotation, I request all the dignitaries on the dais to inaugurate the conference by lighting the lamp. I request the judicial officers, Ms. Sonali Singh and Ms. Shraddha Bhushan, to kindly assist.
Shanti, Shanti, Shanti. Asato ma sadgamaya, tamaso ma jyotirgamaya, mrityormagamaya. Om Shanti, Shanti, Shanti. Asato.
Thank you, my ladyship and my lordships. Now I would like to seek permission from my esteemed chief guest, Honorable Mrs. Justice B.V. Nagratna, Judge, Supreme Court of India, for commencing this conference. Thank you, my ladyship. Today, we at Judicial Academy Jharkhand feel immense pleasure to organize this conference on women's right to property, road to empowerment, as a part of the Golden Jubilee celebration of the establishment of Circuit Bench of High Court of Patna at Ranchi. Our last conference on crimes against women was organized on 10 September 2022, wherein the various facets of crimes committed against women was discussed, and a consensus was achieved on the point that without reducing the numbers of crime against women, the journey of empowerment of women would be incomplete. In further continuation, we at Judicial Academy Jharkhand realize that without a comprehensive discussion of the property rights of women, this deliberation would not achieve a desired purpose. Like all nations across the globe, the property rights of women in India have also evolved after a continuing struggle between the status quo and the progressive forces. The peculiar feature of property rights of women in India is, however, that it cannot be compartmentalized to a single box, as there is a range of diversity subsisting within women in India on lines of religion, caste, and class. The judicial system, bureaucracy, legislature, and the executive need to work together hand in hand in order to deal with the unique problem posed by the non-uniform laws of property rights of women. We hope that the various technical sessions lined up today would assist each one of us in developing an understanding of property rights of women in the road of their empowerment. With this, I now request Honorable Mr. Justice Rangan Mukhopadhyay, Judge, High Court of Jharkhand, to deliver his welcome address.
Namaskar, Johar. A very warm welcome to the dignitaries on and off the dais, as well as the participants. It is an honor and privilege for me to welcome the dignitaries and participants on behalf of the Jharkhand High Court and Judicial Academy to this conclave on women's right to property, road to empowerment, which has been organized by the Judicial Academy in association with Jharkhand High Court and the National Institute of Study and Research in Law, Ranchi, for discussing the issue and charting a course for empowerment of women. I wish to extend my deep appreciation to the Jharkhand High Court for supporting the efforts to further develop the role of national mechanisms for promoting gender equality and the empowerment of women. I want to particularly thank Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, for her commitment to the cause and leadership on women empowerment, and also for her encouragement in organizing this workshop. I am delighted to welcome all the distinguished participants. You have traveled from all regions of the country to be present at this important meeting. I thank and welcome our chief guest, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India. This is her first visit to Ranchi. Through her life, works, and words, she has been a source of inspiration for women in our country. I am privileged in welcoming you, ma'am. Her ladyship, through her landmark judgments, have transformed the areas of education of children, protection of children from illegitimate marriages, child hygiene, shared parenting, and visiting rights, family laws, and commercial laws. Her ladyship has led the Karnataka judiciary in COVID period by taking a number of initiatives, including ensuring online classes, and directed that teaching and non-teaching staffs be treated as frontline workers. We are eagerly waiting to hear the golden words of experience and wisdom from her leadership. I once again welcome you, ma'am. I extend my hearty welcome to Honorable Mr. Justice Aparesh Kumar Singh, Judge, High Court of Jharkhand and Executive Chairman, Jhalsa. My Lord's vast experience in different capacities, including in the matters of Academy, NUSRL, High Court Legal Services Committee, and Jhalsa, has immensely helped the state of Jharkhand and its people. His Lordship's project Shishu has been taking care of more than 1,600 children who lost both parents or bread-earning parent to COVID-19. I once again welcome my Lord, Honorable Mr. Justice Aparesh Kumar Singh. I also extend a warm welcome to my Lord, Honorable Mr. Justice S. Chandrasekhar, Judge, High Court of Jharkhand, and Judge in Charge, Judicial Academy. He is a person with boundless energy and who is always open to suggestion. His efforts in particular is the reason we all are here. I once again welcome you, sir. I am honored to welcome Brother Justice K.P. Dev, Judge, High Court of Jharkhand, who has always been proactive in putting forth his valuable suggestions, and this conference is also no exception. I welcome you, sir. I am honored to welcome Honorable Mr. Justice Rajiv Sahai in-law, former Judge, High Court of Delhi. His Lordship has very kindly accepted our invitation to share his experience on the issue and traveled a long distance for us. Justice in-law is known for his in-depth knowledge of law and his meticulous approach to each subject. I welcome you, sir. I'm delighted to welcome Professor Dr. K.R. Varikulla, Vice Chancellor, NUSRL Ranchi, and Professor Dr. Mrinal Satish, Professor, NLSUI Bengaluru. Both of you are contemporary legal luminaries. Your participation and sharing of thoughts will be of immense value to the participants. I welcome you both, sir. I'm happy to welcome Mrs. Kanta Singh, Deputy Country Representative, United Nations Women India, New Delhi. Your working experience in the field will enlighten us immensely. You are most welcome in this conference, ma'am. I welcome Dr. Vandana Singh, Advocate, Jharkhand High Court. She has been working for women issues in the state of Jharkhand for long. Her thoughts will help in better understanding of the issues in the context of the state of Jharkhand. I am very happy to welcome my sister and brother judges of the Jharkhand High Court. Their Lordship's blessings, support, and involvement have helped us all in our endeavors, including this one. I welcome their Lordships once again. I also welcome the spouse of our honorable judges who have graced this occasion. I welcome the Registrar General, High Court of Jharkhand, the registry members, the Principal Secretary, Department of Law, and the Director, Judicial Academy. I also accord a warm welcome to the judicial officers who all are present in this conference. I also welcome the officers of the district administration and the Secretary of the Welfare Department. I also extend my warm welcome to the members from the print and electronic media. Welcome to all. Thank you so much.
Thank you, my Lord, for your warm welcome address. I now request Honorable Mr. Justice Shri Chandrasekhar, Judge, High Court of Jharkhand, cum Judge in Charge, Judicial Academy, Jharkhand, to deliver the introductory address.
Honorable Mr. Justice V.V. Nagratna ji, Honorable Judge of the Supreme Court of India, Honorable Brother Justice Aparesh Kumar Singh, Judge, High Court of Jharkhand and Executive Chairperson of the Jharkhand State Legal Services Authority, Brother Justice Rongon Mukhopadhyay, Brother Justice K.P. Dev, respected sister and other honorable brother judges of the Jharkhand High Court, Honorable Justice Rajiv Sahai in-law, former judge of the Delhi High Court, respected madams, Rajiv Ranjan ji, Advocate General, Rajendra Krishna ji, Chairman, Jharkhand State Bar Council, Arun Kumar Singh ji, Additional Chief Secretary, Rajkumar Malik ji, Director General of Police, our other speakers today, Professor Dr. Keswar Rao, Professor Dr. Minal Seth, Ms. Kanta Singh, Mrs. Dr. Vandana Singh, Registrar General, other registrars, and registry members of the High Court, Law Secretary, Principal Judicial Commissioner Ranchi, Director, Additional Directors, and other officers of the Jharkhand State Judicial Academy, Member Secretary, Jhalsa, and Secretary, High Court Legal Services Committee, District Judges, Additional District Judges, Chief Judicial Magistrates, and the police officers who have been nominated for this conference. Media persons, dear students, ladies and gentlemen. Right from Cleopatra in ancient Egypt and continuing through biblical era, ancient Greece, ancient Roman and Byzantine empires to ancient India, we can read some kind of property rights conferred to women. In Europe and America also, there was somewhat a liberal society in this regard. And then, Middle East was also not a no rights zone for women. In the Hindu religion, gods are not exclusively male. Rather, the deity of knowledge, Ma Saraswati, and the deity of wealth, Ma Lakshmi, are women. Mother Mary is worshipped no less than Jesus Christ, and in fact, she has the highest position in Islam amongst all women. She has been mentioned in Quran by the name of Maryam more often than in Bible. Notwithstanding that, there has been great disparity between social and legal status of women in the society. Written in 1405, Christine de Pizan has stated in her book, The Book of the City of Ladies, that the oppression of women is founded on irrational prejudices in the society. A woman is asked about her husband, while a man is asked about his rank. So then started a kind of women's freedom movement, freedom from shackles of patriarchal society. In India, from middle of 19th century, the reformists started speaking in favor of reforms in education and customs. Savitribai Phule started the first school for girls in India in 1848. Tarabhai Shinde wrote India's first feminist text, Stri Purush Tulna. Anusuya Sarabhai is considered as mother of women's labor movement in India. Amrita Shergill's oil painting, Young Girls, was accredited globally when she was only 19. Aruna Asaf Ali, who was posthumously awarded Bharat Ratna, was mayor of Delhi, elected in 1958. Captain Prem Mathur was the first ever woman to fly an aeroplane from India. Cornelia Sorabji was the first female advocate of India, the first female graduate of the Bombay University, and the first Indian woman to study at Oxford University. And Rukma Bai was the first woman practitioner of medicine from the London School of Medicine for Women. Are few names of the women of substance who led the crusade in the early years. Across the globe also, there has been a wind of change. The struggle for women's rights has gained enormous support across the globe, and its amplitude and reach have been such that at least 8 countries have their first woman head of state, with Barbados, Estonia, and Moldova having women as president or prime minister for at least a part of the year. And of course, United States of America has the first woman vice president. Albania has a record 70% women cabinet. Germany got its first gender equal cabinet, and Iraq and Kosovo exceeded their gender quotas for parliament. The spirit is so high that even during the pandemic of COVID-19, the march on to the road to empowerment did not stop. It started with 2020 Tokyo Olympics, which kicked off with almost gender equal athletes. 49% of participating athletes were women. Then a woman won the Oscar for Best Directors Academy Award 2021 for the movie Nomadland. Maria Ressa shared Nobel Peace Prize, and it was only started just 2 days back when a French woman was given the Nobel Prize for Literature. Promoting gender equality is seen as an encouragement to greater economic prosperity, and therefore, female economic activity is considered as a common measure of gender equality in any economy. However, in India, it is a matter of concern that 50% of the population of the country, which can be capable of changing the political course of the country, is deprived of many basic rights, and a part of it, even the right to property. In Charu Khurana versus Union of India, the Honorable Supreme Court has held that the women should become parties in the decision-making process in a democracy that is governed by the rule of law. The Honorable Supreme Court has further said, the sustenance of gender justice is the cultivated achievement of intrinsic human rights. A UN body has also proclaimed that gender equality means that women and men, and girls and boys enjoy the same rights, resources, opportunities, and protections. It does not require that girls and boys or women and men be the same, or that they be treated exactly alike. In Rana Nahid versus Sahidul Haq Chisti, the Honorable Supreme Court has said that India has committed to adopt a woman-friendly legal system and woman-friendly policies and practices. In the first technical session, some of the wording issues would be discussed in the context of the role of judges, and in the other 2 technical sessions, in the context of rising crime against women and access to justice. I believe that the judgment in Prabhatyagi versus Kamlesh Devi, delivered by the Honorable Supreme Court on 12th of May 2022, shall also be discussed. The Honorable Chair, Honorable Mrs. Justice B.V. Nagaratna herself being the author. It's a long way ahead, and sometimes there may seem no end to the road to empowerment. Still we can see light at the end of the tunnel. Since the day in 2009, when Honorable Mr. Justice B.V. Nagaratna famously declared, we have taken the oath to the Constitution. Her Lordship has been seen as the flag bearer of the Indian judiciary. Indeed, we have our own Ruth Bader Ginsburg. Honorable Mr. Justice V.V. Nagaratna, a compassionate judge, filled with immense sense of justice. Thank you.
Thank you, my Lord, for your address highlighting the long-drawn and yet ensuing struggle of women against centuries of injustice, inequality, and against the shackles of patriarchy. With this, I now request my Lord, Honorable Mr. Justice Apresh Kumar Singh, Judge, High Court of Jharkhand, to deliver his address.
A very good morning to all. Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India. Honorable Justice Sri Chandrasekhar. Honorable Justice Rangan Mukhopadhyay. Honorable Justice Kailash Prasad Devji on the dais. My esteemed sister and brother judges of the High Court of Jharkhand. Honorable Mr. Justice Rajiv Sahai, in-law, former Judge, Delhi High Court. Professor Dr. Keshav Rao, Vice Chancellor, NUSRL, Professor Dr. Mrinal Satish, NLSIU, Bangalore, Ms. Kanta Singh, Deputy Country Representative, UN Women India, Sri Rajiv Ranjan, Learned Advocate General, Dr. Mrs. Vandana Singh, Advocate, Jharkhand High Court, the Chairman, State Bar Council, learned advocates, senior officers from the state, the nominated DSPs of all the districts, Special Branch and Anti-Corruption Bureau, the nominated senior revenue officers of all the districts, judicial officers present in the gathering, law students from NUSRL, friends from the media, a very warm johar and namaskar to all of you. It's an honor for all of us to have an opportunity to hear respected Mrs. Justice B.V. Nagaratna ji, Judge, Supreme Court of India, who is one of the most powerful voices on women empowerment in contemporary India today. In relation to women's status, law is often seen as a tool of social progression that has been employed to bring necessary reforms through protective and preventive legislations. Economic empowerment is the bedrock of empowerment. The right of property gains significance as a medium for the realization of other rights, especially right to equality and right to have a life with dignity. According to the second report of the UN Women, titled as Realizing Women's Rights to Land and Other Productive Resources, women's rights to land and other productive resources are essential to realizing their rights to equality and to an adequate standard of living, among many other human rights. Women's secure access to land and resources supports their independence and autonomy, provides for the day-to-day needs and those of their families, and allows them to weather some of life's most difficult challenges. Based on the analysis of 180 countries, the report highlights that 164 countries explicitly recognize women's rights to own, use, make decisions, and use land as collateral on equal terms with men. However, only 52 countries guarantee these rights both in law and in practice. In the Indian context, the role of women being indispensable during the British era also, legislative attempts were made for the upliftment of the status of women through legislative enactments, such as Sati Prohibition Act, the Hindu Widows Remarriage Act, the Special Marriage Act, 1872, the Child Marriage Restraint Act, 1929, the Hindu Women's Right to Property Act, 1937, and the Dissolution of Muslim Marriage Act, 1939. Post-independence, the framers of Indian Constitution actively ensured that the state, under the constitutional mandate, takes positive steps for women empowerment and conferment of equal status. At the same time, the Constitution prohibits any discrimination on the basis of sex. The amalgamation of these positive and negative rights can be seen particularly in Part 3 and Part 4 of the Constitution. Article 14 provides that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 15(3) enables the state to make special provisions for women. Article 39 in particular directs the state in particular to frame policies towards securing the citizens, men and women equally have the right to an adequate means of livelihood, that there is equal pay for equal work for both men and women, that the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. Article 42 provides that the state shall make provision for securing just and human conditions of work and for maternity relief. There are negative rights like Article 15(1), under which the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Article 16(2) also provides for that no one should be discriminated on these grounds in any employment or office under the state. Apart from constitutional guarantees, there is a plethora of legislative enactments and policies that have been passed to give effect to the constitutional mandate. Legislation in this respect has played a very crucial role in bringing about a change in the unequal socio-economic status of women in India. Through the Hindu Marriage Act 1955, the Hindu Adoption and Maintenance Acts 1956, the Hindu Minority and Guardianship Act 1956, equal status of a woman with a man has been statutorily recognized in matters of marriage, divorce, adoption, and guardianship. Additionally, special provisions have also been made for women as an acknowledgement for their entitlement of special rights. Similarly, the personal laws of other religion also have been made in consonance with the principles enshrined in the Constitution through enactments or judicial pronouncements. As far as the law related to inheritance of property is concerned, the same has been ensured through the provisions contained in Hindu Succession Act 1956. Section 14 of the Act provides for property of female Hindu to be her absolute property. In a significant step, the legislature enacted and passed the Hindu Succession Amendment Act 2005 that was primarily aimed to remove the gender inequalities under the Act. It makes daughters co-partners in the joint Hindu family in her right as sons. The amendment is an important step towards gender equality and abolition of patrilineal system of inheritance prevailing among Hindus. The Protection of Women from Domestic Violence Act 2005 is yet another enactment for the protection of women. The Act provides for punishment for domestic violence committed by a husband and his relatives and also provides legal assistance for women suffering from domestic violence. Article 42 of the Constitution imposes an obligation upon the state to make provisions for securing just and humane conditions of work and for maternity relief. Some of the legislations which promote the objectives of the article are such as the Maternity Benefit Act 1961, the Payment of Bonus Act 1965, and the like. Judicial pronouncements. The role of the judiciary has been significant in supplementing and implementing the legislative enactments and the constitutional mandate through a number of progressive decisions rendered over the decade. The role of the courts is also important in cases where there are legislative gaps which need to be filled to render complete justice. One of the bright examples of such a judicial intervention has been in the case of Visakha and others versus State of Rajasthan and others, 1997 6 SCC 241, where the Honorable Supreme Court, in the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at workplaces, laid down the guidelines and norms for due observance at all workplaces or other institutions until a legislation was enacted for the purpose. In Madhu Kishwar versus State of Bihar, 1996, 5 SCC 125, Sections 7 and 8 of the Chota Nagpur Tenancy Act were challenged on the premise that the provisions are discriminatory and unfair against women since they provide for the male succession to property in the male line. The Honorable Supreme Court held that the exclusive right of male succession conceived under Section 7 and 8 has to remain in suspended animation so long as the right of livelihood of the female descendants of the last male holder remains valid and in vogue. It is in this way only that the constitutional right to livelihood of a female can interject in the provisions to be read as a burden to the statutory right of male succession, entitling her to the status of an intervening limited dependent or descendant under Section 7 and 8. In Associate Bank Officers Case 1998, 1 SEC 428, the Honorable Supreme Court held that the women workers are in no way inferior to their male counterparts, and hence there should be no discrimination on the ground of sex against women. In Vinita Sharma versus Rakesh Sharma, 2029 SEC Volume 1, page 1, the Honorable Supreme Court holding that Kopasni rights of a daughter under Section 6 of the Hindu Succession Act is from her birth, in the same manner as a son with same rights and liabilities, observed that the amended provisions of Section 6(1) provide that on and from the commencement of the Amendment Act, the daughter is conferred the right. Section 6(1)(a) makes daughter by birth a co-partner in her own right and in the same manner as the son. It contains the concept of the unobstructed heritage of Mitakshara co-partnery, which is by virtue of birth. In Ministry of Defense versus Bhavita Punia, 2027 SCC 469, where it was claimed that women officers engaged in short service commissions must be considered for permanent commissions at par with their male counterparts, the Honorable Court opined that an absolute bar on women seeking criteria or command appointments would not comport with the guarantee of equality under Article 14. Implicit in the guarantee of equality is that where the action of the state does not differentiate between two classes of persons, it does not differentiate them in an unreasonable or irrational manner. In Joseph Stein versus Union of India, 2019 3 SEC 39, the Honorable Court struck down Section 497 of the IPC related to the offense of adultery and observed that in treating a woman as chattel for the purposes of this provision, it is clear that such provision discriminates against women on grounds of sex only and must be struck down. Section 497 is destructive of and deprives a woman of her agency, autonomy, and dignity. In Aparna Bhatt and others versus State of Madhya Pradesh and another, 2021 SCC Online Supreme Court 230, the Honorable Court highlighted the role of courts in combating with judicial stereotypes while dealing with the cases of offenses against women. The mandate of the constitutional provisions and the judicial pronouncements can be effectively realized only if there is a proper and significant implementation of the law at ground level. In this regard, the role of the state agencies and institutions becomes crucial. One of the ways to reach out to the women population of this country is through several schemes launched by central and state governments. Such initiatives include livelihood programs, scholarship for study, credit linkage, pensionary benefits, health and maternity benefits, etc. These schemes have the potential to promote gender justice and help reduce their exploitation. Most often, due to lack of capabilities, they are deprived of availing the benefit of these schemes. The Legal Services Authorities Act 1987 had been enacted to provide free and competent legal services to the weaker sections of the society, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Section 12C of the Act recognizes a woman as a person entitled to receive free legal services under the provisions of the Act. Various efforts have been made by the Jharkhand State Legal Services Authority in empowering women with holistic approach in coordinated manner through various awareness programs, projects, and schemes such as Project Atmanirbharta, Project Shakti, Project Sahyog. Project Atmanirbharta has been specially designed for the all-round upliftment of rural, tribal, forest-dwelling women by laying down a mechanism for identification of the relevant social security schemes and a framework for facilitating access to such measures by women. The project was launched in 2020. Until December 2021, a total number of 203,167 women have been benefited from the project. I have to mention here the recently launched project Shishu, during the second wave of COVID 2021, under which the orphan children were provided rehabilitation. Till now, about 1,600 such orphans who have either lost both their parents or the bread-earning parent have been rehabilitated. They have been linked to various schemes of the government. I personally had the privilege of going to several such homes of such orphans. I can say with pride that of all these 1,600 orphan children, none of them have gone to the orphanage. And their studies have not been interrupted. Jhalsa has been monitoring their rehabilitation and that the schemes are not discontinued every quarter with reports coming from every DLSA. I can narrate one instance where I personally went to a remote village in Ranchi district. I visited other districts also, where the three daughters, they had lost both their parents, and there was an aged grandfather, about 75 years old. All these three girls came to me and requested that they wanted to study in Kasturba Gandhi Residential School. And because of our visits to the homes, and I made it a point that none of these orphan children should come to any of our offices to take the benefits. The people from the district administration, the doctors, the teachers, all used to assemble at each of such orphans' homes in order to give them the benefits and to ensure that their health condition, education, general upbringing, whether they have a home or not, they should be provided that Pradhan Mantri Awas Yojana. If there are no lights, they are provided electricity. There are some schemes for that also. If they do not have gas connection, they are provided. So in this way, these children have been rehabilitated, and these three particular girls, we ensured that they got admission in Kasturba Gandhi Residential School. I recently went to meet them for the third time. After 1 year, they were much more healthy and in much more better shape and mental state of mind. And all three are in 7, 8, and 9, class 7, 8, and 9. So the purpose of sharing this experience with this August gathering is to convey that actually the letter of the law under different legislations or the judicial pronouncements can actually take shape and be implemented at the grassroots level if all of us are sensitized and reach out to these people, especially from the women folk. And once they are properly educated and these benefits are linked to them, I'm sure that would ensure the proper empowerment of these female gender of our population. Similarly, other schemes which I just mentioned, Project Atmanirbharta, they provide for economic independence and empowerment of women at ground level, ensuring their active and full participation in the setup. They built a foundation that all-round upliftment of women is not limited to issues of income only, but it is multi-dimensional experience. They also tend to ensure that discrimination faced by women as a result of intersectionality is overcome. As all of us know, intersectionality refers to a form of oppression that arises out of the combination of various oppressions which together produce something unique and distinct from any one form of discrimination standing alone. This issue of gender discrimination from the viewpoint of is relevant in the Indian scenario and has also been discussed by the Honorable Supreme Court in Patan Jamal Wali versus State of Andhra Pradesh 2021 SCC Online SC 343. Therefore, despite the constitutional provisions and the judicial pronouncements, what is most essential is that the women belonging to all social and economic strata become aware of their rights and entitlements. Social awakening and a change in the mindset and attitude are equally important. Education is the most important thing which we should ensure. I'm sure this conference is going to address all these very important issues concerning the right to property of the woman, road to empowerment of women in the coming technical sessions of the day. With the valuable insights of the learned speakers and the blessings of Honorable Justice Nagaratna ji, it is surely going to provide remarkable impetus in the movement for women empowerment. I thank the Academy for giving me an opportunity to speak before you. Thank you. Jai Hind.
Thank you, my Lord, for your address, emphasizing on the importance of women's right to property in the road of empowerment with the help of various legal provisions and judicial pronouncements. Our Chief Justice of High Court of Jharkhand, Honorable Mr. Justice Dr. Ravi Ranjan, who could not attend this conference due to unavoidable circumstances and exigencies, has sent us a message which is as follows. It gives me immense pleasure to learn that the Judicial Academy Jharkhand, Ranchi, is organizing a conference on women's right to property, Road to Empowerment, on 8th October 2022 to celebrate the Golden Jubilee year of the established laws, their financial independence, but further helps in establishing gender equality in the society by breaking its rigid patriarchal structure. In Indian society, women have always been treated inferior to men, both in terms of inheritance rights and the capacity to hold property independently. There are many restrictions on inheritance rights and women's properties rights which do not exist for men. However, in recent times, the entire gamut of law of inheritance has undergone significant reforms and judicial pronouncements, and now women enjoy equal rights and share in property. Prior to 2005, the Hindu Succession Act 1956 did not give any co-partitionary rights to women over the ancestral property. It discriminated against women solely based on the gender and violated the fundamental right to equality under Article 14 of the Indian Constitution. To do away with the Act's discrimination against women, the Hindu Succession Act 2005, the Amendment Act, was enacted, which gave daughters a right to their parents' property. Still, many challenges, including societal attitude, mindset, and gender biases, have to be surmounted by Indian women in order to effectively execute those rights. I wish good luck to the Judicial Academy and participants of the conference and hope that the conference will discuss and deliberate on all issues relating to women's right to property. Jai Hind. We are honored to have with us a distinguished chief guest, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India. Her ladyship was born on October 30, 1962, as the only daughter of late Honorable Mr. Justice E.S. Venkataramaiah, the former Chief Justice of India. Her ladyship did her graduation in History Honours from Jesus and Mary College, University of Delhi, and later earned a degree in law from Campus Law Centre, Faculty of Law, University of Delhi in the year 1987. In the same year, her ladyship enrolled herself as an advocate with the Karnataka State Bar Council. Initially, her ladyship worked with the firm Kesari & Co. Thereafter, her ladyship started independent practice from 1994 till elevation as a judge in 2008. Her ladyship practiced in a wide variety of cases such as arbitration, land acquisition, service law, administrative law, constitutional law, commercial law before the Supreme Court, Karnataka High Court, and trial courts. Her ladyship also represented Karnataka State Legal Services Authority. Her ladyship was also appointed as amicus curiae in many matters, one of such matters being the rejuvenation of lakes in the city of Bengaluru. Her ladyship has been very vocal about women's right and empowerment. The noted judgment of Prabhatyagi versus Kamlesh Devi was authored by her ladyship, wherein women have been provided the right to residence in a shared household. With this, I now request my ladyship, who has championed the cause of women's rights throughout her career, to deliver her an address on the topic, the evolution of women's right to property in India, a facet of empowerment.
Namaskar, Johar, and a very good morning to everybody. Honorable Shri Justice Aparesh Kumar Singh, Judge High Court of Jharkhand and Executive Chairperson, Jhalsa, Honorable Shri Justice S. Chandrasekhar, Judge High Court of Jharkhand and Judge in Charge, Judicial Academy, Jharkhand, and Governors of the Academy, Honorable Shri Justice Rongan Mukhopadhyay, Honorable Shri Justice Kailash Prasad Deo, Judges of the High Court of Jharkhand, Honorable Sister and Brother Judges of the High Court of Jharkhand, gracious spouses of the Honorable Judges, Learned Advocate General for the State of Jharkhand, Additional Chief Secretary and Additional Director General of Police, Justice Rajiv Sahai and Law, former Judge, High Court of Delhi, Principal Secretaries, Department of Law and Welfare Department, Sri Rajendra Krishna, Chairman, Jharkhand State Bar Council, Dr. Mrinal Satish, Professor of Law at National Law School of India, University, Bengaluru, Sri Mohammad Shakir, Registrar General, High Court of Jharkhand and other registrars, Sri Sudhanshu Kumar Shashi, Director, Judicial Academy, Jharkhand, Professor Dr. Keshava Rao Varakula, Vice Chancellor, NUSRL, Ranchi, Mrs. Kanta Singh, Deputy Country Representative, UN Women India, Delhi, learned judges of the District Judiciary of Jharkhand, Dr. Mrs. Vandana Singh, Advocate, High Court of Jharkhand, Ranchi, learned senior advocates and members of the bar present, distinguished invitees, faculty of NUSRL, Ranchi, police officers who are in large numbers, members of print and electronic media, ladies and gentlemen. A long list whom I have addressed. I hope I have not left out anybody significantly, but as an omnibus clause, I address all of them together. At the outset, I thank the High Court of Jharkhand, Judicial Academy, Jharkhand and National University of Study and Research in Law, Ranchi, for inviting me to inaugurate this symposium on the theme, Women's Right to Property, Road to Empowerment. The evolutionary trends in the Indian narrative on women's right to property is a continuous journey from patriarchy towards parity. Hence, the topic I have chosen for my address is the evolution of women's right to property in India, facet of women's empowerment. Women empowerment has of late of discussion when we speak of development of our nation. For our nation cannot develop unless our women are also developed and empowered. It may be defined in several ways. In my view, women's empowerment has 5 major components or facets. First, securing a woman's sense of self-worth. Second, a woman's right to determine the right choice of action. Third, a woman's right to have access to opportunities in every field of activity and resources, including ownership of land and property. Fourth, a woman's right to have the power to control her life, both within and outside the home, of course, subject to her duties to her family and as a citizen of the nation. Fifth, her ability to influence the direction of social change so as to create a more just and economic order, both nationally and internationally. In short, empowerment of women is social, economic, political, educational, and psychological empowerment. It is not only imperative, but also crucial for all-round development of society and the nation as a whole. The narrative of women's empowerment would be incomplete without referring to the aspect of her right to property, including economic power in a broad sense of the term, which includes her right to livelihood also, which is the pertinent topic of discussion today. Women's access to property is a crucial determinant of more equitable gender patterns of wealth distribution, household bargaining power, and decision making. Studies by development economists suggest that securing property rights and inheritance rights are amongst the most effective means of achieving women's empowerment, particularly in developing countries. When we think of economic empowerment, it is mostly in the sense of inheritance of property as far as Indian women are concerned. For a large number of Indian women do not have separate property as such. Therefore, laws and policies that seek to improve the position of women in matters of right to property and inheritance have been advocated and endorsed, in addition to those which seek to improve economic opportunities for women. Being a student of history, I must recall Lord Macaulay's words when he said, "Women's laws on property rights must be to secure uniformity where you can have it, diversity where you must have it." It's a well-balanced statement, uniformity and diversity. Property rights of Indian women is a matter involving an interesting interplay between various socio-legal forces, and this necessitates an approach which does not compromise on cultural diversity in an attempt to achieve uniformity. In seeking to achieve such balance, women's property rights in India are governed by personal laws, both uncodified and now codified in most areas, reformed and made applicable by the parliament or the state legislature, but it is religion specific. However, the law in this regard must be studied and applied in light of the culture of the Constitution, after duly recognizing the close interface between personal laws and the Constitution of India. Talking of the Constitution of India, we are all reminded of Article 44, which speaks about uniform civil code. It is an ideal to be achieved because our country, which comprises of persons belonging to different religions, communities, ethnic and tribal groups, confront complexities of great magnitude. While much is to be achieved in this regard, as Article 44 is a directive principle of state policy, its absence cannot be a reason to escape the constitutional discipline anchored in Part 3 of the Constitution, particularly in Articles 14 and 15 on the aspect of gender equality. Justice Aparesh Kumar Singh has, in his lecture, given in details not only the provisions contained in the fundamental rights, but also the directive principles. But I must say that Article 15(3) of the Constitution, in fact, permits special rights and protections to be extended to women in order to secure that they are protected from any form of manifestation of discrimination. Such constitutional protection and affirmative action are to be borne in mind while enacting, applying, or interpreting any law which has implications on the rights of women, even when such laws are based on personal law systems. Any attempt to have a uniform civil code must ensure that it is women-centric while not being disadvantageous to other genders. That would bring about gender parity in Indian society. I always would advocate gender parity and not just being women-centric. Of course, women empowerment is necessary, but at the end of the road, we should have gender parity and not just have women-centric laws. Gender parity is most important in a healthy society. Through the course of my talk, I would discuss the evolution of the law on women's right to property in India within the time permitted. Distinct personal laws are based on different religious groups and sects, and such plurality is a facet of Indian multiculturalism, especially when I stand here and speak in the state of Jharkhand. I cannot miss the great presence of the tribal population in Jharkhand state and the neighboring states who have their own unique systems of laws, customs, and the question now is whether we should look at it in the prism of the Constitution or from the prism of other personal laws, or look at it only from the prism of the tribal population. That is the debate which may have to take place today, I suppose. I begin with the property rights of Christian women and touch upon it in a brief manner by saying that sections 31 to 49 of the Indian Succession Act 1925 deal with all aspects of succession and inheritance of properties insofar as Christian women are concerned. A watershed decision of the Supreme Court of India, which decided questions as regards the applicability of the Indian Succession Act 1925 to all Christian citizens in India, is Mary Roy versus State of Kerala. The Supreme Court reasoned and declared that the law applicable to interstate succession among Christians of Travancore area in the state of Kerala is the Indian Succession Act 1925, with effect from April 1st, 1951, being the date on which the Part B States Laws Act came into effect. As per the Indian Succession Act, a Christian woman, whether a widow or daughter of the deceased, is entitled to a specific share. Such share is to be determined based on the identity of the other living relatives of the deceased. If the male family member dies intestate, leaving behind his widow and children, the widow receives 1/3 of his estate, and the remainder is to be apportioned equally among the children, irrespective of their gender. If the heirs of the deceased are relatives other than children, the widow receives 1/2 of the deceased estate, and another half shall devolve upon the other relatives of the deceased. Another salient aspect of the law of the land as to property rights of Christian women is that a woman's property is treated as self-acquired property, irrespective of the actual mode of acquisition. Thus, a share of a Christian widow is of considerable one, depending on whether she has children or not. As far as Parsi women are concerned, Section 50 to 56 of the Indian Succession Act deals with the succession applicable to Parsis. As far as Parsi women are concerned, there is an equitable distribution of property between the sons and daughters and the widow of a deceased Parsi male who dies intestate. The share of a daughter is not affected by her marital status. Each parent of the deceased would also be entitled to half the share of each child. As far as the property rights of Muslim women are concerned, broadly speaking, the Islamic scheme of inheritance discloses 3 features. First, the Quran confers specific shares to specified categories of individuals. Second, the residue devolves upon the agnatic heirs, or in the absence thereof, on uterine heirs. Third, bequests are limited by law to 1/3 of an individual's estate. However, under the Islamic law of inheritance, a descendant daughter is eligible to claim a share equal only to half of the share of a son. A widow governed by Mohammedan law is entitled to claim 1/8 of her husband's property if the couple had children, and 1/4 of her husband's property if the couple had no children. Another interesting feature of Mohammedan law governing the property rights of women is in relation to the nature of claim a woman has over meher or dower. The Supreme Court in Kapurchand versus Kadarunitsa said that meher is a debt due from a husband to his wife, recoverable by her on his death from his estate. It is an unsecured right. The right is like an unsecured creditor, and the claim may be satisfied out of her deceased husband's estate to the exclusion of the claims of other heirs. This right is recognized as the widow's right of retention. Coming to the rights of Hindu women, I must say that the restriction on Hindu women's property rights have undergone change, and current laws governing these rights are more liberal than those of ancient Hindu society. Hindu society since time immemorial provided women with property known as Tridana, and it mainly came from gifts given at the time of a marriage. However, women were denied property rights in the ancestral property, and their right to succession in the landed family property was limited. I am reminded here of what has been said by Manu in the Manusmriti on the rights of women. I'm not saying it in a deprecating manner, but what he really meant, he said that, and I quote, that a woman's father, her father protects her in childhood, her husband protects her in youth, and her sons protect her in old age. And a woman is never fit for independence. Ignore the fact that the woman is never fit for independence. Ignore that. But what I wish to say is, the protection that is given is not because a woman is weak, but the fact that it is in the context of empowerment also. It must be read in the present times in the form of affirmative action. But I feel sad to say that in her childhood, a girl has to file cases against her father or male relatives under POCSO. A wife has to file cases against her husband for cruelty or dowry harassment. And a senior woman citizen has to file cases against her son or other male relatives for maintenance under the Senior Citizenship Act. Just see in the prism of what Manu said, if you look at it from the point of view of an affirmative action, protection means affirmative action. But now we are having only rights given to women, whether a girl child or a wife or a senior woman citizen, to enforce her rights and not really an affirmative action. So therefore, it is how you look at it, the quote. In the 19th and 20th centuries, they witnessed a passage of several pieces of legislation that were intended to remove some of the barriers to full and equal property rights of Hindu women. We have what is called the Hindu Succession Amendment Act 2005, made to the Hindu Succession Act. Now we have what is known as the Mitakshara school of thought, where the commentary is of the Yajnavalkya Smriti authored by Vijnaneshwara. And he has said that there are rules of inheritance by birth in respect of various schools, such as the Benares, Southern and Western Indian schools. Another commentary is Jumut Vahana's Dayabaga prevalent in the Bengal region. Mithila, Benares, Bombay and Dravida are the subdivisions of the Mitakshara school. The manner in which property rights are vested in women and their rights over different categories of properties thus vary under each school. I need not explain to this enlightened audience that when it comes to women's property in Hindu law, we have to confront with what is known as co-pastorally property and self-acquired property. Co-pastorally property is again divided into ancestral property and joint family property, which is not ancestral. Joint family property consists of property acquired with the aid of ancestral property and property acquired by an individual co-partner without such aid, but treated by them as property of the whole family. Co-pastorally property devolved on the principle of survivorship, and the right of a male Hindu over co-pastorally property was vested at the time of birth. But under the Hindu Law of Inheritance Amendment Act 1929, certain female members of the joint family were included in the orders of succession by way of interstate succession. But this was only in the field of self-acquired property of males and not with regard to the ancestral property. Over time, we have in British India what is known as the Hindu Women's Right to Property Act 1937, which crystallized the property rights of a widow in the event her husband died intestate. It was called a widow's estate, which was only a life estate, and it would revert to her male reversioners on her demise. Prior to 1937, the Act, the widow had only a right to maintenance with regard to co-pastorally property. It is noteworthy that in Mysore state, that is the princely state of Mysore from where I come from, the Mysore Legislative Assembly enacted in 1933 itself the enlightened legislation giving rights to a widow of a predeceased son, and the widow of a predeceased son of a predeceased son a right of inheritance to the deceased property even when the deceased had left a male issue. Such persons were even allowed to claim partition, though they had only a limited estate. But the Hindu Succession Act 1956 is a harbinger of enhanced property rights to women. Section 14 of the Act confers absolute right in favor of a Hindu woman in relation to any property acquired by her before or after the commencement of the said Act. Of course, there again there are certain exceptions by the proviso. After the passing of the 1956 Act, whatever share of property a woman had received in lieu of her maintenance became her absolute property, which aspect has been discussed by the Supreme Court in V. Tulsamma Reddy versus V. Shesha Reddy, 1977, 3 SCC 99. Therefore, the rights of a Hindu woman over property held by her are unfettered and include the right to dispose the property by way of a will or by sale, subject to the exceptions dictated in Section 14 of the Act. But on 9 September 2005, that is nearly 50 years thereafter, Section 6 was amended and there were two departures made with regard to the position of law as it stood under the Hindu classical law with regard to ancestral as well as joint family property. Now, before I go to that amendment, I'd like to speak on the introduction of the device of what is known as a notional partition under Section 6 as it stood prior to the amendment, and where certain classes of or categories of women who were mentioned in Class 1 of the schedule to the Hindu Succession Act were granted or given a right in the ancestral property of the deceased co-partner to the extent of the share of the deceased co-partner, and in that way her right for the first time was included in the co-partnery property of the deceased co-partner. As a result, the principle of survivorship which prevailed prior to that, insofar as the male heirs were concerned, was given up. The Act provided that on the death of a male co-partner, there would be a notional partition, whereby Class 1 female heirs were given a share in the property that would fall to the share of the deceased co-partners as if a partition had taken place prior to his death. The salutary implication of employing the device of notional partition on the inheritance rights of women is demonstrated in Gurpat versus Hirabai, which is a judgment of the Honorable Supreme Court in AR 1978, Supreme Court 1239, authored by none other than the Chief Justice Y.V. Chandrachud, as he then was, wherein he said that the propositus dying, leaving behind his widow 2 sons and 3 daughters, would mean that the widow would get a share equal to that of her son. The court observed that under the Bombay School, the widow's share must be ascertained by adding the share to which she is entitled to at a notional partition during her husband's lifetime to the share which she would get in her husband's interest upon his death. The second is that under the Mitakshara school of Hindu law, no female was treated as a co-partner in a joint family, and that happened only by the amendment of 9 September 2009. This position has now evolved and changed in favor of daughters only and not widows, because as you increase the share of the children, male or female, the share of the widow ultimately goes down. And this is by the amendment made to Section 6 of the Succession Act. In order to appreciate the evolution of law in relation to property rights of Hindu women, it is apposite to study that certain state amendments were brought to the said Act prior to the central amendment on 9 September 2005. Andhra Pradesh, Karnataka, Tamil Nadu and Maharashtra recognized daughters as co-partners much prior to the Central Act. But there again, there was a discrimination against married daughters who were excluded from inheriting co-partnery property as a daughter. Thus, marriage of daughters was a reference point to deny a daughter of a share equal to that of the sons. The 2005 amendment recognizes daughters as a co-partners by birth in the same manner as sons and subject to the same liabilities and rights as sons with regard to co-pastory property. The distinction between married and unmarried daughters introduced by the state amendments has been excluded. On an analysis of Section 6 of the Succession Act after the amendment, the following two aspects emerge. First, on and from the commencement of Hindu Succession Amendment Act 2005, that is with effect from September 9, 2005, in a joint family governed by Mitakshara law, a daughter of a co-pastor by birth becomes a co-pastor in her own right in the same manner as a son. Second, having made the said declaration, subsection 2 of Section 6 of the Act states that any property to which a female Hindu becomes entitled by virtue of the amendment shall be held by her with the incidence of co-pastory ownership and shall be regarded, notwithstanding anything contained in the Act or any other law for the time being in force, as property capable of being disposed of by her by testamentary disposition. This right must be read harmoniously with Section 14 of the Act, which states that property of a female Hindu is to be her absolute property. There were several questions which arose after this amendment came, which I will address in my second session while I chair along with Justice Enlaw, and I won't continue with that now. Those questions were considered in Prakash versus Pulvati, Danamma versus Amar, and Mangamal and T.B. Raju, and ultimately the matter was referred to a larger bench in Vinita Sharma versus Rakesh Sharma, and in that case, the Supreme Court held that though the rights can be claimed with effect from 9/9/2005, the provisions are of retroactive application. They confer benefits based on the antecedent event, and the Mitakshara co-pastory law shall be deemed to include a reference to a daughter as a co-partner. In fine, it was laid down that the daughters are co-partners on and from September 9, 2005, irrespective of their date of birth or whether their father is alive or not. In holding that partition of the entire co-pastory property would not be effected by way of notional partition, the Supreme Court in Vinita Sharma made a departure from the earlier judgment in Uttam versus Saubhag Singh by saying that the joint family system and the co-pastory does not come to an end. It held that partition of the entire co-pastory would not be effected by way of a notional partition, that the fiction of notional partition could not be employed for the purpose of ascertaining the share of a surviving co-partner who would continue to remain joint until a division of the property by metes and bounds. The question regarding the applicability of the 2005 amendment to pending suits was also considered in Vinita Sharma, and the Supreme Court held that the 2005 amendment, which brought about a change in the laws as to the body of co-partners, must be borne in mind while deciding all matters regarding partition, that the law operating on the date of passing the final partition decree is to be applied. This is also a departure from the classical Hindu law, which says that the moment a signal is made or an intention is given to sever status, partition takes place. But the Supreme Court, in order to bring in the amendment and to give effect to it, said that the actual partition will take place on the day the final decree is drawn up in pending suits, that is, when it is to be by separation by actual metes and bounds. With regard to property rights of tribal women, I must say that it is largely governed by customary laws. It would not be wrong to say that tribal communities in India are unique social groups, tremendously varied, yet sharing the common blanket of constitutional protection and a concomitant insulation from the mainstream. Under the Indian Constitution, tribes are recognized as scheduled tribes, and under the 5th and 6th schedules provide for their privileges and guaranteeing protection to their traditional way of life. Schedule 5 of the Indian Constitution identifies special privileges for those geographical areas of which the bulk of the population belongs to scheduled tribes, including the state of Jharkhand, while Schedule 6 applies to the tribal population of the northeastern states of Assam, Meghalaya, Tripura, and Mizoram. Article 244 states that the governor may make regulations for the peace and good government of any area in a state, which is for the time being a scheduled area, including a bar on alienation of tribal land. Inheritance in India allow many tribes to be governed by their customary law in order to protect the unique traditions and customs in India. Recognizing this, subsection 2 of section 2 of the Hindu Succession Act contained in this act shall apply to the members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution, unless the central government by notification in the official gazette otherwise directs. The intention of Parliament seems to be that the traditional laws of the tribals must be protected, and they cannot be just brought into the scope and ambit of the Hindu Succession Act. Therefore, the aforesaid overriding provision, which begins with a non-obstante clause, categorically states that the Hindu Succession Act would not apply to members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution, unless the central government notifies. I'm not sure whether the central government has till date notified any scheduled tribe to be coming within the scope of the Hindu Succession Act. I'm sure I'll be enlightened by the discussion which would take place today. But tribal women are in the intersection of the disadvantaged groups of Indian society. Despite extensive constitutional protection and safeguards having regard to their culture and customs, very ironically, the customs and traditions and rituals that the Constitution protects also restricts the scheduled tribes women to rightfully inherit property. A nationwide survey reported that women in India own less than 2% of the total farmland. And so far as the scheduled tribe women are concerned, it is far less. Undoubtedly, there exists a plethora of socio-economic and institutional barriers that mediates the purchase of land by women. Therefore, inheritance becomes the primary channel for women to acquire ownership rights in the property. Therefore, the need arises to address the aspect of women's inheritance of land through molding a policy as well as securing practice thereof. A need arises for ensuring gender equality and empowerment of women both socially and economically. Law and policies that improve the position of women in matters of property and inheritance needs to be endorsed and advocated. I have one suggestion to make, and that is when the state government allots land to the weaker sections of the society, or when a development authority allots sites, or there is any other state largesse which is distributed, there must be some kind of a reservation, at least 30% to be allotted to women, and the rest may be allotted to the other genders. So that there is this reservation of 30% to exclusively women will bring about an empowerment, and this is a policy which must be considered by the state government. Since I am delivering this address in the state of Jharkhand, it may be apposite to look into the land and property rights of the tribal women in the state of Jharkhand. Of course, the Chota Nagpur Tenancy Act and the Santal Parganas Tenancy Act supplementary provisions of 1949 are there, but I would not go into those details because I may not be sufficiently educated on the finer aspects of those enactments. But broadly speaking, what I have understood is that the customary practices related to a Santal woman's right to inherit ancestral property is namely the Taban Jom, Ghar Di Jamai and Ghar Jamai system. And if my understanding is right, there again she inherits property through her husband and not directly as such If there is any misunderstanding on this regard, I may be enlightened during the course of the day. It is undeniable that one of the primary means of property ownership for both men and women is through inheritance, and the subject of inheritance is governed by the religious personal laws. Undoubtedly, over time, the rights of women and men belonging to different religions have been reaffirmed and clarified by the courts. However, the same set of rights do not necessarily extend to aspect of inheritance by tribal women. They are mostly customary, and we all know, to this enlightened audience, I need not say what a custom is. Therefore, while interpreting the laws on the basis of custom, we need to again be very clear of what a custom is and what a custom is not. Finally, I would conclude with the following words. It is fairly clear that evolution of the property rights of women in India has undergone reformation to overcome systemic discrimination against women. While the theme of gender parity has been the centerpiece of contemporary inheritance laws, empirical literature on women's inheritance rights in India suggests that significant gender bias persists despite the reforms, disabling women, particularly rural women, to effective. The real objective of a legal regulation should be to change social and particularly gender attitudes. Such attitudinal changes are essential, which are based on an understanding that the changes in law targeted to provide enhanced rights to women were demanded by societal changes. Male co-partners should have an enlightened attitude which recognizes the needs, interests, and rights of their female counterparts. Sensitization to bring about such attitudinal changes is the need of the hour. If male co-partners invite their sisters to have a share in the property, probably the sisters will not ask for their actual share. They'll have a concern for their brothers, and they may say, let us have a give and take and divide the father's or the mother's property in the best possible means. That is one way of avoiding litigation and disruption of family life. While the discourse today has been predominantly on one aspect of women's empowerment, that is through vesting of property rights, women ought to be guarded by law in a multitude of areas. Safety at workplace, education, health are some of them. Reservation for women in the matter of allotment of house sites, I said, and other largesse for women must be focused upon by the state governments. Crime against women in the context of property rights must receive focus by the police and the concerned authorities in the state governments. Having stated that the laws designed to overcome systemic discrimination against women, particularly in relation to their right to property, must be accepted by male members of a family and by the society at large, I must also caution the women. This is not anti-woman. I'm not saying anything against women, but I'm only cautioning women to say that the women must seek to enforce their rights to obtain property from the ancestral or marital families only when such property will contribute in a significant manner to their financial and social status. In cases where women possess sufficient means of living and are fairly stable financially and have the financial capacity, or what I would call the creamy layer of women, she may exercise her sensibility and not insist on claiming or enforcing her share of property, especially when her co-sharers can significantly benefit from such property. Such an attitudinal change and inter se accommodation of significantly towards achieving gender equity in the real sense of the term and in aid of maintaining peace and stability within the family, which is the basic social unit of our society. Now, by virtue of the amendment made to Section 6 in 2005, we have all experienced a tremendous docket explosion at all levels, right from the civil court right up to the Supreme Court. That's a good sign. But at the same time, I would advise women that they must settle wherever a settlement is possible in the cases, either through mediation or through Lok Adalat, so that the family relationship is restored. Imagine a brother getting a notice from the court when a sister has filed a case. Nothing wrong with it, but what happens to the family relationship of the brother and the sister? Therefore, while rights are being given to women, at the same time, I must advise women to see that there is a settlement of the property. After all, it is the property of the ancestors or the self-acquired property of the father. It is not their self-acquired property. It is a matter of inheritance. Therefore, it is necessary that the family relationship is restored even when there is a suit filed, at the earliest by some kind of a give and take between the brothers and sisters in the family. Equally important that women strive to keep intact the finer feminine sensibilities of kindness and care. Independence of women, financial or otherwise, must not have implication on the more domestic aspects of a woman's life, like marriage and family. In my opinion, women inherently have tremendous biological potential for compassion, forgiveness, and sensitivity, and the same must be kept alive always. On this note, I once again judge in charge for having invited me to deliver this lecture and to share a few of my thoughts. I seek pardon from the women who are present here or who may have heard this address, but I have said it all in the context of gender parity and for restoration, unit of society, and which is something very unique to India as compared to anywhere else in the world. Thank you and namaskar.
Thank you, Your Ladyship, for your detailed address on the various land laws and laws of inheritance under different classes of religion, tribes, classes, and states in India, which has been eye-opening in regards to the diversity existing in the realm of women property rights. With this, I now request Honorable Mr. Justice Kailash Prasad Dev, Judge, High Court of Jharkhand, to give the vote of thanks.
A very good morning to everybody present in the august gathering. My Lord, Honorable Mrs. Justice V. Nagarathnam ji, Judge, Supreme Court of India, Honorable Mr. Justice Apresh Kumar Singh, Judge, High Court of Jharkhand at Ranchi, Honorable Mr. Justice Sri Chandrasekhar, Judge, High Court of Jharkhand at Ranchi, Honorable Mr. Justice Rangan Mukhopadhyay, Judge, High Court of Jharkhand at Ranchi, Justice Rajiv Shai and Law, former Judge, Delhi High Court, other honorable judges of the dais, Advocate General Mr. Rajiv Ranjan, Additional Chief Secretary Mr. Arun Kumar Singh, Mr. R.K. Malik, Additional Director General of Police, Mr. Rajendra Krishna, Chairman Jharkhand State Bar Council, and my officers nominated by the state government, particularly the land revenue officers, the other dignitaries of the dais, spouse of the Honorable Judge, respected Bhabhijis and gentlemen. It is indeed a matter of great honor and privilege for me to propose the vote of thanks on this memorable occasion when we have assembled here for a day-long discussion and deliberation for a cause of very deep concern, women's right to property, road to empowerment. An event and of immense importance in the backdrop of the situation of women and the society. I have every hope that this seminar is a path-breaking steps towards the empowerment of women, considering the deprived and dependent status of women enjoying in the society. In the ancient Hindu society, it was presumed that the daughter would one day be married and sent to different house. The only time they would get property at the time of marriage, that is Stridhan, or in other auspicious occasion. The status of women's right to inherit property has always been a bleak. There has been a constant struggle and agitation on their part to acquire equal rights to inherit their father's and sister's property. Slowly but surely, things have changed. The gender unequal provisions are now laws of the past. The law is now finally settled, and the Hindu women have been accorded equal rights in the property as Hindu men. Thus, Hindu women have led a long way for the classic Hindu law, which gave them very limited rights to the Hindu Succession Amendment Act 2015. Additionally, the role of the judiciary in this regard is also commendable, as without its assistance, the right would have merely existed in the legal statute, but not in the Hindu society practically. Recently, in the case of Vinita Sharma versus Rakesh Sharma 2029 SCC 1, the Honorable Supreme Court in the year 2020 has held that the women will be qualified for co-pastorate status regardless of whether they have born before or after the amendment. The court gave the act of retroactive application. The court gave a choice on the two positions, first and foremost giving women equivalent co-pastorate freedoms since birth and inconsequential to the father being alive upon the date of amendment. It is a matter of great common knowledge that the Honorable Madam has been championed the cause of women through various judgments, and the same is apparent from the recent one authored by her in the case of Prabhat Tyagi versus Kamlesh Tyagi 2022 8 SCC 90. This judgment reflects your Lordship's deep concern regarding women empowerment, where your Lordship have not only expanded the scope of shared household, but also redefined the term domestic relationship. Holding the expression right to reside in the shared household not only includes actual residence, but also constructive residence in the shared household would go a long way in protecting women from being shelterless. In the case of Satyajit Kumar and others, the state of Jharkhand and others, decided by the bench of Honorable Mr. Justice M.R. Shah and Honorable Mrs. Justice B. Naganathanam ji, struck down the policy of Jharkhand government giving 100% reservation to the local resident in the scheduled area. Being a mother herself, her ladyship was able to understand the feeling faced by the mother in leaving behind the children during the working hours, and in a very important and significant decision issued direction to the established crutches in the City Civil Court, Bangalore, for the children of the staff. Your Lordship also issued direction to the Karnataka State Bar Council for considering special financial package to the lady advocates. Your Lordship has served the President Karnataka Judicial Academy, wherein she introduced the first time module for the trial judge on the gender equality, child-related laws, and the environmental laws. Her ladyship's contribution to the literature is of immense and remarkable. I am falling short of words in thanking Madam Justice V. Raghunathan ji, Judge Supreme Court of India, who has been kind enough to enlighten us with the gracious presence. We are highly privileged to be in audience to the inaugural address of Madam regarding women empowerment through evolution of right to the property of women in India. Madam, the whole nation is looking forward to a day when the history will be created and your Lordship will be adorned with the highest chair of the Indian judiciary. I, on behalf of Jharkhand Judiciary, thank you, Madam, for core of my heart and wish you good health for your future responsibility. I take this opportunity to thank Honorable Mr. Justice Apresh Kumar Singh, Judge High Court of Jharkhand, and would be Judge Tripura High Court for his introductory address, which reflects your Lordship's deep and sincere commitment towards the women empowerment. My Lord is on the way of a greater future responsibility, though it will be a great loss to the Jharkhand. But I am sure he will illuminate and premises of Tripura High Court with his dynamic vision and judicial wisdom. Today's program is physically happening today, but it was mentally designed and planned long ago in the mind of the Judge in Charge Judicial Academy, Honorable Mr. Justice Sri Chandrasekhar. I take this opportunity to thank my Lord for taking endeavors in organizing series of lectures in the Golden Jubilee year. A program of this kind does not happen in a day. It's my Lord's constant effort and leadership to ensure that the Judicial Academy becomes an institution par excellence. Thank you, my Lord, for the unmatched energy and all the sincere efforts to make Judicial Academy an abode of Ma Saraswati. I take this opportunity to thank Honorable Mr. Justice R. Mukhopadhyay, Judge High Court of Jharkhand, for his infectious energy, which is highly inspiring and constant source of motivation for all of us. I further convey my sincere gratitude and thank to all the Honorable Judge sitting, including single lady judge of this High Court, Honorable Mr. Justice Mrs. Justice Anwar Awad Chaudhary on this occasion, as well as former Judge Mrs. Jaya Rai, as we have only witnessed two lady advocates to be elevated in this High Court in 50 years of the tenure. I also thank Honorable Mr. Justice Rajiv Sahai and Law, former Judge Delhi High Court, Professor Kesav Rao Virkula, Vice Chancellor NUSRL, Professor Dr. Minal Satish, Professor of Law NLSIU Bangalore, and participant Mrs. Kamta Singh and Dr. Mrs. Vandana Singh. I also thank team of the Judicial Academy, member of the registry, the law secretary, OSD Judicial, and other magistrate, principal district judge, and other officers. If I have missed anybody to address, I am sorry for that, but I also welcome them and also welcome the members of the electronic and print media. With these words, I pay my deepest regard to all of you. Thank you.
Thank you, my lord. I now request all to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We will start with the technical sessions after a short tea break. I request a chief guest, Honorable High Court judges with spouses, former judges, Advocate General, secretaries, senior government and senior police officials, members of the bar, registry members, principal district judges, and the press and media to proceed towards Damodar Hostel for tea. The tea arrangements for all the participant judicial officers, police officers, revenue officers, law students, legal researchers, and others has been made at the right side of the auditorium. I request all participants to please join us for the first technical session after 15 minutes. I request everyone in the auditorium to please rise for a distinguished guest. Please be seated. Welcome all to the first technical session of the Conference on Women's Right to Property, Road to Empowerment, organized by Judicial Academy Jharkhand in association with High Court of Jharkhand and National University of Study and Research in Law, Ranchi, as a part of the Golden Jubilee celebrations of the establishment of the Circuit Bench of High Court of Patna at Ranchi. To chair this topic, we feel honored to have with us a distinguished chief guest, Honorable Mrs. Justice B.V. Nagratna, Judge, Supreme Court of India. To discourse upon this topic, we have with us the gracious presence of Honorable Mr. Justice Rajiv Sahai, End-Law, former Judge, High Court of Delhi. My Lord did his graduation from Hansraj College, Delhi University. Thereafter, he did his LLB from Campus Law Center, Delhi University, and enrolled as an advocate with the Bar Council of Delhi in July 1982. My Lord then practiced in the Delhi High Court and the subordinate courts, mainly on the original side in the fields of real estate, family, civil, and arbitration laws. My Lord was appointed as additional judge of the High Court of Delhi on 11th April 2008 and became the permanent judge on 6th July 2011. My Lord served as a judge of the Delhi High Court for more than a decade before retiring on 12th of August of 2021. My Lord is an expert in civil law and is known for his remarkable judgments, amount with depth, reasoning, and precision. We are fortunate to have such a distinguished person with us. With this, I request my lady, the chair, to begin with the first technical session.
A very good afternoon to everybody. Honorable Justice End-Law, Honorable Judges, distinguished invitees and participants of this first technical session. It is on women's right to property, role of judges. I touched upon some of the cases which have arisen subsequent to the amendments made to Section 6 of the Hindu Succession Act, 1956. But before going into that, I would say that how judges can make a difference with regard to the manner in which women's right to property could be secured. But before that, I would also say that how the role played by a judge can help in women's empowerment generally, not only by enhancing the rights of women when cases come up before the judge or when he decides a case enforcing rights in favor of women, but the role a judge plays, whether a male judge or a female judge, in the court as a presiding officer while dealing with the cases can enhance women's confidence in the adjudicatory system or make her skeptical about it. For example, when a presiding officer is recording evidence of a woman witness, a child witness, a girl witness, a lady, a youth in her middle age or old age, how she answers and how her answers are considered by the presiding judge while recording the evidence in the trial court, sessions court. What kind of mannerisms he or she exhibits in the court when the woman witness is answering in the witness box becomes very important. Secondly, when a woman is a litigant seeking enforcement of her rights, she may be putting up a novel right on the basis of the existing broad rights. how the judge would view such a case, whether he would consider it from the women, he or she would consider it from the women's perspective and seek to ascertain whether such a right can be enforced, whether such a right can be read into the existing provisions of law and thereby enhance the law or not. That is another duty. The comments that a presiding officer, whether a male or a female, would make in a court of law, when a woman is a litigant, when a woman is an advocate, when a woman is a staff in the court of law also is very important, because it shakes their confidence in the system, or it gains their confidence in the system by how the presiding officer treats such a category of women. It may be a lady advocate, whether a male or a female judge would just dismiss an argument because it is coming from a young lady or a young advocate or a very old advocate who is a lady. Old means elderly. What is the kind of impression that we judges give in the court of law while deciding cases when we come across various stakeholders in society, particularly those stakeholders who are women? As I told you, women litigant, women advocate, woman witness, woman staff, how we treat each one of them in the adjudicatory process, and our role as judges in the adjudicatory process should be very, very circumspect and bearing in mind the consciousness that these women are there and how we speak, what mannerisms we display, how we comment, whether we laugh or whether we scorn it off, whether we cut short an argument. If, for example, if a young girl is arguing a matrimonial dispute, a judge shouldn't ask her, "Madam, you're making such arguments. Are you married?" For example, if such questions are asked, what is the confidence level of such a lady advocate? Therefore, we, whether we are male or female judges, we have to be conscious of the various stakeholders in the adjudicatory system. Then, that is with regard to our role in adjudication. Then secondly, when we decide cases, as I told you, though it is with regard to women's right to property, I may expand it to say that when questions or issues come up before the court, trying to enforce new rights concerning women, or reading new rights into the existing provisions, in what way we show our concern to such arguments which are put up before us on behalf of women litigants. Then we as judges on the administrative side, how do we treat our women colleagues, our women officers of the district judiciary, the women staff of the courts at whatever level of or hierarchy it may be? That also becomes important. Now, before I hand over the baton to Justice Endlaw, I would like to quote two examples from my experience, with your permission, sir. First is with regard to the administrative side. A lady was expecting a child. She got, as per her merit, selected as a civil judge, junior division. A letter came from the Registrar General of the High Court saying that she must come to take her oath. And we all know if a person does not join duty on that particular day, the seniority is affected. So she came to the Registrar General and she said, "Sir, I have received this letter, but I don't know whether I can come and take my oath because my delivery date is due and I'm very apprehensive about it. So kindly help me." And of course, she couldn't attend the oath ceremony because she delivered, she was in the nursing home or the hospital, question arose whether she would lose her seniority because she had not taken the oath. And I can tell you that in the High Court, some of my male colleagues said, yes, she should lose her seniority because she has not taken the oath on that day. But I said, no, it's a matter of Article 21. It is only a woman who delivers. You cannot expect her to come from the hospital bed, from the labor room to the court to, so to say, to come and take oath immediately after her delivery. Otherwise, she will lose her seniority. And I must say that my male colleagues were very kind enough to accept my argument. And my Chief Justice said, yes, let her come and take the oath. I will administer the oath in the chamber. On the 5th day of her delivery, she came and took the oath, and she became a civil judge, and she did not lose her seniority. So therefore, role of judges means role of women judges, so have more women judges. Secondly, there was Panchayat Raj institutions. Somebody, one of the faculty, she was discussing with me. There was a provision under the Karnataka Panchayat Raj Act where we have Zilla Panchayat, Taluk Panchayat, and where they say the Adhyaksha or the chairman, as we say Adhyaksha or the chairman of the Zilla Panchayat or Taluk Panchayat, where their elections are take place, it is on the basis of reservation. So while making the reservation under the provisions, there was a proviso, 2 provisos in fact. One proviso said that one female Adhyaksha should not succeed another female Adhyaksha. That means 2 female Adhyaksha should not consecutively be holding the post of Adhyaksha or the chairman or the president of that local body. And there was another provision which said that 2 women cannot simultaneously be Adhyaksha and Upadhyaksha, that is chairman and vice chairman. And I found that to be discriminatory. Why? If 2 men can succeed one after another as Adhyaksha consecutively, why not 2 women succeed one after another? Secondly, if 2 men simultaneously can be Adhyaksha and Upadhyaksha at the same time, why not 2 women be Adhyaksha and Upadhyaksha at the same time in a local body, Jilla Panchayat or Taluk Panchayat or whatever you may call? And though that question did not directly arise, but in the context of challenge made to the reservation of the post of Adhyaksha and Upadhyaksha, I suo moto heard on that and struck down those provisions. Consequently, I hope now 2 women can simultaneously hold the post of Adhyaksha and Upadhyaksha in a local body, and 1 woman Adhyaksha can succeed another woman Adhyaksha in the Jilla Panchayat or Taluk Panchayat as the Adhyaksha. So these are 2 things which I wanted to share with you, where the sensitivity of a woman judge would be greater, and hence again have more women judges. Thereby will increase access to justice. But by that, I am not discrediting the role played by male judges in enhancing women's rights, the recent being the abortion rights of women of the Supreme Court, judgment authored by Dr. Justice D.Y. Chandrachud, and the previous one being giving the short service commission officers, making them permanent commission officers for women in the defense forces, Babita Punya's case, also authored by Justice D.Y. Chandrachud. But coming to women's right to property, there are many questions which were raised in the context of the amendment made to Section 6 of the Hindu Succession Act, whether it is prospective, whether it is retrospective, whether it is retroactive. Then questions whether the daughter who succeeds as a son, co-partner, whether she herself can start a co-partnery property in her line all these questions arose. I think Justice Enlaw will be speaking about all of them. I'll not touch upon it, except that the controversy is now at the stage of Vinita Sharma versus Rakesh Sharma, where many questions have been answered, but that will not stop many more questions and issues being raised in the courts of law. Naturally, they will be initially raised in the trial courts. How the trial court judges will view these issues would depend upon the sensitization they have, the amount of study that they have made on the development of law with regard to Section 6, the arguments that would be made insofar as the women are concerned. Then in the case of the shares being ascertained by a preliminary decree, matters pending in the stage of final decree, whether Section 6 will be applied. Now Vinita Sharma says that it has to be applied. As I said, a divide has been set in now with regard to what is partition. Earlier, partition was severance in status. From joint tenancy, it would come to tenancy in common. The moment a co-partner expressed his intention to separate or divide. But the Supreme Court, in order to bring in the amendment to existing cases, has shifted that principle to say that severance of status will ultimately take place when a final decree is drawn up, when in the final decree proceedings, even if the preliminary decree was drawn up prior to the amendment. So that is a innovation of the Supreme Court vis-a-vis the classical law of partition. The other aspect is, as I told you, the issues which may arise in the implementation of the property rights to women and how the courts would enhance or enforce those rights. And for more of that, I will leave it to Justice Enlaw to carry on. I thank you all for your kind attention. Sir, please.
Thank you, ma'am. A very good day to all of you. This is my first foothold in your state. So when I received a message from Justice Chandrasekhar, I was quite delighted, and I thank all of you for giving me this opportunity. And in any case, I have always been of a firm opinion that with the participation in such forums, one always goes wiser. First of all, to speak for half an hour, you have to study for at least 6 hours. So you read so many things which you may not have. And then listening to the other speakers since morning, I have been enlightened. I particularly would mention the comment made by Justice Nagaratna about how the 2005 amendment of the Hindu Succession Act has been to the prejudice of the widow. I had never looked at the said provision from that point of view. I am no longer a judge, but maybe it's a fodder for some of you over here to work on it further. Because you see, I am not saying for Justice Nagaratna, because I am a firm believer that the jurisprudence originates from the district courts, from the court of original jurisdiction. So a lot of times I have seen the judges. In Delhi, we have been very fortunate. Most of the district judiciary in Delhi does not hesitate, and we have had benefited. We have all benefited from it. So part of the jurisprudence which has risen from the Delhi is either because the district judiciary does not hesitate to innovate, or another reason is that in Delhi we have a original jurisdiction in the Supreme Court. So some disputes come directly in the High Court, come directly to the High Court instead of traveling through the route of the district courts. But friends, what I speak and what I would like to share with you today is out of my experience, and largely I would say from my appearances. My practice was in civil law, and out of 25 years that I practiced, I think for about 20 years, I was mostly in the district courts. Only in the last 5 years, I shifted exclusively to the High Court. And so what I present for your consideration today is the good practices, what I saw the judges following, and a few instances I would mention, what I felt should not have been said, and of which they are very old incidents, but of which I was reminded today in the context of this topic. So I've scribbled some points, so actually Justice Nagaratna in a nutshell has said what I intended to say. I am not going to share with you any case law or any statutory provisions, and I seek pardon for that, because I am a firm believer in that the definition of a good lawyer or a good judge is who knows where to find the law. As long as you are inquisitive and you can find the law quickly, whether you know the law, whether you know the precedents or not, in my view and in my experience, doesn't really make a difference. I have always started, whenever I was practicing largely on the original side, I always started with the proposition by picking up a bare act. A lot of clients used to run away because they thought that I did not know the basic law also. But a lot of them appreciated this practice also, that at least you see the law, you use the books which are lying in your office. Most of the offices, we find them to be just decorative. So on the eve of my becoming a judge, you know, a lawyer is very apprehensive when he is to become a judge. When I was feeling afraid, I thought, what can be so difficult about it? The law is so well settled, all statutory provisions have been interpreted. I have to just apply the precedents to the factual situations which will be coming up before me. But then from the very first day, I was surprised, because I realized that the factual situation presented in each case was not matching most of the decided cases. And when one picked up the statute again the same thing unraveled, that in the facts of that case, the statute would have a different meaning than what I had always known. And those statutory provisions I had read hundreds of times. But they always throwed up a meaning in the context of facts of this case. Now, why I share this with you today is because when this topic was circulated and the Director Judicial Academy suggested that I speak on the case law empowering women's property rights. So I made a counter suggestion because I said that, look, the judges will be told the law, they can find the law themselves. So I would like to speak on the role which the judges can perform, because see, right to property is a creature either of a customary or a common law or of a statute law, and which is not the domain of the judges. Except to a little extent, there is an exception which I'll be touching shortly later. So I thought that what role can a judge play in empowering the property rights to the women? Then that thought on the eve of becoming a judge came back to me, that what have I learned in my years as a lawyer and as a judge? How have I seen the judges performing a role which either empowers women's property right or which takes away from them? So a few thoughts came to my mind which I have jotted down. Now the first thing is that first of all, why are we talking of this subject today? That why should you as judges even think about it or do anything or follow any of the thoughts which have emerged today in the this session which we have been having since morning about empowering? See, if you go back into it, what is property? Property acquisition is actually an act of purchasing with money. Now, earning money has largely been a domain of men in the past. So that is why most of the property was held by men. the women, though, were contributing equally, because after all the unit, see, today we are all talking of the Nobel Prize also, which was mentioned, has been given in physics in the field of quantum physics. Now, what is, if we see constitution, quantum constitution is the individual. Actually, one of the Supreme Court, I think Justice Chandrachud again, he has referred to this, that we have to apply constitution to each citizen, not in general. That we have to see the constitution playing out in the context of a human being. So, when we start applying that, we see that though the women traditionally have been contributing to the growth of the society equally as men, but they were not earning in terms of money. So since they were not earning in terms of money, they were not going out of the household to purchase property. So therefore, all property came to be held in the name of the men, and that's why all this debate and the statutes about inheritance and everything started. But a different thought now. The first thing is that the society has changed today. We have started recognizing the non-monetary role of women in the growth of society as such, or in the growth of the family, which is the ultimate aim for acquisition or for holding the property. So, and in fact, one of the judgments came which opened my eyes to this fact. I don't remember which court. There was a case of payment of motor accidents claim compensation. And the woman was not earning anything. She was a homemaker. So the difficulty arose that how it is to be assessed. And in that judgment, I read for the first time that you have to assess in terms of her contribution just because she is not earning money. And particularly as judges, all of us know that even if our spouses are not working, how much they are contributing. I think, speaking for myself, what I have been able to achieve has been largely because I didn't have to bother about the family. I didn't have to spend as much time of the family. So somebody was contributing to the family. So that is why the need to see we have to bring that equality in the society, because women, though they have always been equal contributor to the growth, but unfortunately did not come to hold property or acquire property, and therefore the need today for all of us as judges to give a thought. I'm sorry, I continue to say all of us. I'm no longer a judge. That need for all of us to do whatever we can to bring to correct that imbalance which has happened in the leases or most of the allotments of land. Now, for the last about a decade or more, they have been insisting that if an allotment is being sought in the name of a man, the name of the wife will be joined along with it. So most of the allotments for the last decade or more have been in the joint names compulsorily of the man and the wife. They don't ask for it when the woman is seeking the allotment. They don't say that you have to join the name of your husband in that. So, and I feel that, I'll give you an example why I feel we had a very, since a large number of you have been in Delhi and are familiar with Delhi, you may be aware there used to be a very popular chaat place called Sweets Corner in Sundanagar. Now the story behind that is no longer there for the last about 8 years. The story behind that Sundanagar, that very prime shop in Delhi, is that the owner of it lost it in a gambling session during Diwali. And he lost it to somebody else who was not interested in the business of Taj, who started running a jewelry store over there. Now, what I want to place for your consideration is just consider the fact that had that business and shop been not in his exclusive name, but in the joint names of him and his wife, probably such a situation which he himself, I am sure, must have viewed in the morning, would not have arisen, because there was no way he could lose something which he did not own. And when I was thinking of this example, another thought came to my mind, that maybe the Mahabharata folklore also would not have happened if the kingdom was partly owned by the spouses of the Pandavas. There was no question of their losing it. So it is in the benefit of the society also. And the society, see the societal changes which are happening. Now we have it in a judicial precedent. One of the judges in the Supreme Court has said that a daughter is a daughter for life and a son is yours. A daughter is yours for life and the son is yours till he gets married. So when when daughters are behaving this role, I think we all owe a duty to see that whatever we can do as judges for empowering women, we should be doing. I missed out the judicial precedents. The judicial precedents also, which have been spoken of since morning, are with respect to development of law and for empowering women. So we, whatever little role in whatever little disputes which are coming for adjudication before us, we should be performing our role in that. Now, I'll place before you a very interesting case, which Justice Nagaratna in the last judgment of May, which has been spoken since morning, has been advanced. We had the case of S.R. Batra under the Domestic Violence Act, which said that a household does not mean the household or the owner, a house owned by the mother-in-law or father-in-law. So with the result, whatever started happening in Delhi, and I happened to be sitting on the original side at that time, a large number of suits filed by in-laws against the estranged daughter-in-law for removing her from the property were being decreed on the first or second date, and a decree for possession was being passed. Or if the estranged daughter-in-law came for injunction to the court, we were denying injunction. So there were, I think I myself must have passed 7 or 8 decrees for possession like that. Then one day I used to just read the website of the High Court every day that what judgments are coming from our court. So one day I came across a judgment of, I don't mind sharing the name, Justice Rekha Palli. She took the view contrary to that. She distinguished S.R. Batra, and I was appalled. I rang her up. I was still her colleague at that time. And I said, you've gone against the grain. And she said, no, I've mentioned that judgment. I said, yeah, I also. But she said, I thought it was wrong, so I did it. And she did it very wisely. Now, this I'm placing for your consideration that how these changes in law can start. She was entertaining an original suit. So she made a change. I have noted down, but I think since we are running short of time, how she distinguished S.R. Batra's case. And sure enough, immediately the appeal went to the Supreme Court, and Justice Ashok Bhushan, and I think he was heading the bench, 2 other judges, they upheld her view. So a change in law happened. I really wonder what happened to all those women against whom I passed the decree for possession, which in retrospect was wrong. So, but this is how the original jurisdiction can initiate a change. Though slightly out of context, I'll give you another example of how small things done can lead to a change. When I was sitting on the original, I sat largely on the original side as a judge also. So a lot of examples which I am going to give to you will be from that. There was a case for specific performance of an agreement of sale of immovable property. And in Delhi, we have a system that unless the suit is accompanied with an application for interim relief, it does not come before the judge. It goes to the joint registrar, who is also a judicial officer. So that suit came up for the first time at the stage of framing of issues after 7 years of institution. There was no injunction. And the defendant, who was the owner of the property against whom the suit had been filed, he was appearing in person. And he said that, look, I had agreed to sell the property when my son was ailing, and I wanted the money for it. My son is now no more. Now my wife is in a very bad condition. So I said, there is no injunction. Why don't you sell it? He said, nobody is willing to buy it for less than 50% of the price because of the principle of lis pendens. And it was a gross case. There was no case for the plaintiff, which is evident from the fact that the plaintiff did not even bother to seek interim injunction restraining the owner from selling the property. So fortunately, the plaintiff was also there in person. So I asked him that, all right, why are you pursuing it? You are not even restraining him. He said the price was X, today it is X plus so and so. So I want to pursue the thing. So in my understanding, I said that, all right, lis pendens will apply subject to his depositing the difference in the court, so that in the end, if he loses, at least the defendant gets compensated. Fortunately, that judgment was upheld in the division bench, but then it went before Justice Ravindran. Now, Justice Ravindran is a very steeped in civil law, and he knows his basics, and he has been a trial lawyer. So he said that, no, this is wrong. But he said that the concern is correct of the original judge. The concern that because of the applicability of lis pendens, loss is being caused, and he will have no way to recover that loss if the suit is dismissed after another 5 years. So we have to find a cure for it. So he said the cure is that the applicability of lis pendens can be dispensed with. Now, there is no earlier judgment saying that lis pendens can be dispensed with. We all assume that lis pendens automatically attracts to a property the moment a suit is filed. So what why I cited this example is because I consider this also as a very good example of how your act of innovation or doing something can lead to a change in law. So what Justice Rekha Palli did, she did it, of course, wisely. She discussed S.R. Batra. She distinguished it. As a High Court judge, she could not have said S.R. Batra of the Supreme Court was wrong. But she created some reasons to differentiate, but which led to a debate. If she had not done that, maybe it would have continued that, because earlier what was happening, we used to pass a decree for possession on the first or second date, and the SLP used to be dismissed, that it is in accordance with law. So some change happened because there was a original thought. Now the more important thing what Justice Nagaratna has already told you is about facilitating access to justice. I think that is where the judge's role is most important. And I'll again illustrate it with the two examples to which I am personally witness. Of course, they are of long back when there was not so much sensitization in the judges also about gender and a lot of things which have happened in the last 20 years. Don't forget, I am ancient. I'm talking of 35 years back. That I was present in the court, and one of the cases which was going on was between a brother and sister. And that day's hearing went in favor of the sister, and the judge scolded the brother quite a lot. So the sister was turning and going, and her advocate also very happy. Now we all know that these day-to-day hearings don't have any bearing at the end. What may happen on a particular day may not translate into ultimate victory or a loss. So the judge made a very insensitive remark. He said that, "Arey itna khush mat ho, agli baar tere against bhi ho sakta hai." Now, I could immediately see the change in the district court in Delhi. At least my experience is that litigants are always personally present in person. Now, these things make a lot of difference that really affected her, and I could see the brother getting a glee on his face. He was so happy and pumped up. So that was one incident which came to my mind when this topic was being considered by me. The other was a divorce case which I was a witness to. Again, not my own case, but just sitting in the court. And there, from what transpired, the allegation of the husband who had sued for divorce on the ground of cruelty was the infidelity of the wife. And the judge, I think, yeah, she was appearing in person, if I remember correctly, on that particular hearing. So she, again, something favorable to her happened in the hearing, and she turned and started leaving the wife. And the judge said, please pardon my words, Samak chalo, date to leti ja, itni bhi khush mat ho. Now, just imagine the impact that would have on, and why I have chosen to verbatim reproduce these words are because that is where your role comes in. That is what I want you to learn from these incidents, or at least give a thought about it, that how these things make a difference. You know, that again on the husband's face, one could see that, oh, my point has been proved. The judge also considers her like this and is calling her by such a name. One other subject which I want to touch upon is about the another very important role is in appreciation of evidence. I think that is the most important part besides behavior in the court. Justice Nagaratna has already said that how your encouragement, I forgot one point on encouragement. See, again, I have seen these practices being followed by the judges before whom I appeared. There was one particular judge who used to see if there was any woman in the sitting in the court, he would call up because, and he used to say openly, कि भाई इनको जाके घर का काम करना होगा या इन्हें बच्चों को स्कूल से लाना होगा. He would immediately take up their cases, see that they spent the least time in the court. They would, and he used to ask her that what is the best time for you to come to the court on each date. So if somebody said that I would like to come post 2 o'clock, he used to make a note on the file and say that this case will be taken up after lunch on every date of hearing. And similarly, if somebody said that I have to pick up a child at 11 o'clock, so I would like to come after that, he would say, all right, at 12 o'clock this case would be taken up. So there have been judges who have followed all these practices. Now, similarly, another land acquisition judge I saw, these were the days when land acquisition in Delhi was happening a lot, and there used to be massive disbursement of compensation. So whenever the compensation was being disbursed and the part of the money was in favor of a female member of the family, he used to insist that that member should come personally, and he would hand over the check to her, not in the open court, because the entire family used to be sitting over there. So he would call her in the chamber, and I asked him much later that what did he find out in the chamber, what inquiries. So he told me that he used to ask that which account are you going to deposit in? Is that account joint with your brothers? Is that account in your single name? If she did not have a single name bank account, he used to order that, see that the money went into that account. So applying all these things, if they arise in your courts, today we have a direct benefit accounts which are there. So maybe the check or the payment can be directly to that account, which is in the sole name of the woman, because it's all very well to say that, all right, they have a right in property and we are granting that right. But how you are encouraging the access and the ultimate benefit of the right is very important, which is only in your hand. No statute or nothing else can make a difference in that. Only you can make a difference. Now about appreciation. See, in Delhi, I have come across and I have done as a lawyer a lot of such cases where the woman who had signed off a share in the property of the parents came up after some years and said that, no, this happened in such and such circumstances. Now that evidence I felt became very, very important, becomes very, very important, because I, as a lawyer, have done so many cases where I would cross-examine. Like commercial contracts, I would cross-examine those women who were wanting the NOC given by them to be set aside, that literally on the aspect of that, was he holding a gun on your head that you signed it? Because the signatures were invariably admitted in that case. Then one of the judges before whom I had done cross-examination on those lines, and I thought that I had done an excellent cross-examination and I have been able to disprove, he decided against me and he gave a beautiful judgment, and he said that, look, you have to apply the emotions of the woman at the time when it was done. And invariably, my assessment is that most of those NOCs or relinquishment deeds are either in the wake of the death, within the first 1 month or so, or in the wake of a wedding in the family after the death. So when a woman goes back to the family for the brother's sons or the brother's daughter's marriage, at that time they would say that, all right, you please sign this. Now you have to look at it from the point of view of the woman. So that is what appreciation of evidence comes in. You have to see that, was she in a state of mind to say no and be ousted from the wedding in the family? It is equivalent to holding a gun on her head to say sign over here. So that kind of, I don't know what happened to that judgment which I am mentioning, which was decided against me in appeal. But what I want to again place for your consideration is these kind of aspects. Then one matter came where I could use this example before me, in that there was an early death of a man, and he was in government employment, and after him there is a policy of the government that they give a substitute if there is no earning member in the family. So they, a compassionate appointment they give. So in that case, the compassionate the woman came and said that I have applied for compassionate appointment and they are not responding. So when I issued notice and the response came, they said, we have already given compassionate appointment to the brother of the deceased. And when we called for the record, there was a NOC of the widow at that time. And the compassionate appointment was immediately in the wake of the demise, within 45 days or so. So there, again, you see, the option to me, remembering from my past experience, was either to say, go back to in a civil litigation, in a writ jurisdiction, I cannot decide this, that whether it was forceful or under coercion or in what circumstances, which would have taken years and the woman would have lost interest. So I tried some arm twisting in that. All of us as judges know how arm twisting is to be done in the court without causing any harm. And that arm twisting really helped. The brother continued with the employment, but I saw to it that sufficient monetary compensation was given. Another practice which in Delhi we have followed, and I'm sure it must be being followed over here also, is about ensuring that when a large sum of money is being given by way of compensation or otherwise to a woman, invariably what happens is that the male relatives take away the same. So there we have used the Legal Services Authority a lot. The Legal Services Authority monitors that how that money, the large deposit which goes into the woman's account, how is it dealt with, and that it is not taken away by some male relatives or by other family members. I think, ma'am, I've exceeded the time. So I had a few other things, but this was the gist of what I wanted to place for the consideration of all of you. And thank you, ma'am, once again, and thank you to all of you for a patient hearing, I would say.
While Justice Endlaw was speaking, I got some ideas, and I thought with the permission of the audience, I could share with you all. See, with regard to the women's contribution to the family in the form of, you see, looking after the house, where she is called a homemaker, etc., that is not taken as part of GDP at all. Is it not so? It is not taken as part of the GDP. But as Justice Endlaw said from his own experience, that because his wife and family were looking after the welfare of the family, he could contribute, totally devote himself to his career as an advocate and later as a judge. So whether the women's contribution as a homemaker could be added to the GDP is an issue which has to be considered. Then another issue is with regard to right to marital property. That again stems from the earlier issue. Whatever property is earned by the husband after marriage, acquired by the husband after marriage, no doubt it is his self-acquired property. But he is able to earn property, have a good life, a stable economy because of a prudent wife. She saves money, and you know, we all know our mothers and grandmothers, they had a small box in the kitchen where they would keep savings which were given by the husband for the purpose of running the household. Such kind of savings were there, and if she is a prudent housewife, she has a good budget, she will not make undue requests, and therefore the husband is able to save money from his salary or business or whatever and acquire property, but it is registered in the name of the husband. So whether there should be a right to marital property whenever such property is acquired after marriage, particularly important at the time of divorce. In the West, especially in Sweden, any item they purchase, even if they purchase a dining table, it is written, the date is written there on that. Or if you purchase a sofa set, they will write it, so that it is all marital property. That means the contribution of the homemaker is also considered, because she has enabled him to have a stable budget, a stable life, a career, and he could buy all this. Then the judicial precedents for developing women's right, innovation to be made by judges at whatever level they may be. It's not only for the constitutional courts, the High Court and the Supreme Court, to have ideas and to innovate. Even according to me, a judge at whatever level he or she is plays the same role. So innovation is not a monopoly of only the constitutional courts. Even a civil judge, junior division, senior division, district judge, High Court judge, Supreme Court judge can have ideas, think out of the box and innovate. And then the role of presiding officers was discussed, which is various examples were given, what he or she must say or must not say, the mannerisms, etc. Then with regard to land acquisition cases and motor vehicle cases, when it comes to disbursement of compensation, very often we know that how the case itself has been purchased by somebody else, and they get a pittance, the parties actually get a pittance. Therefore, we have all this to put it into the account of the claimants, to give it by a check and not to, disperse as such by cash. And we also have, especially when it comes to motor vehicle accident cases, where the amounts have to be deposited, especially when there are widows and minor children, for long-term deposits in banks, particularly scheduled banks or nationalized banks, 5 years, 10 years, so that they get the reap the benefit of interest. Then when it comes to compassionate appointments, it was said, see, there was a case which came up before me, I don't know whether I was right or wrong, but there they said to the lady who asked for compassionate appointment, the answer given for her rejection was that she is not a dharma patni. That means she is not a first wife. She was a second wife. In Kannada, it was the endorsement. So therefore, she was rejected. Then I said, look, it says wife, and it says widow. The rules of compassionate appointment says widow. Who is a widow? A lady who has lost her husband is a widow. Whether she is the first wife or second wife, how does it matter? If she is entitled to be considered, particularly if the first wife is not what you call eligible, and she is eligible, she cannot be disregarded because she is not a dharma patni and she is a second wife. And therefore, I said that she has to be considered. Ultimately, I don't know whether that has been accepted or distinguished. I'm sure it may not have been accepted. So, this is how we have to innovate. We have to put ourselves, we judges, in the shoe of the women victims, the women litigants, and I won't say only women, I would say all genders, especially now we are expanding the gender to the third gender. We, the judges, have to put ourselves in their shoes to have a feel, a sensitivity of why they have come to the courts, what is troubling them, and what justice we can give to them. With these few words, I thank Justice Rajiv Sahai Enlaw for his words which have come from his heart and which are from his experience, and they are more important than just, citing the case law, etc., because how we have approached certain situations as judges, how we have overcome difficulties, how we have been able to innovate, what sensitivity we had in the matter as presiding officers or judges when the cases and issues come up before the law courts. They are more important than what we only recite by referring to cases. So with this, I think the first session has come to an end. I thank you all for your kind attention.
Thank you, Your Ladyship and Your Lordship, for the valuable insights you share on the roles judges should play who are serving right from the lower rung of the judicial setup to the constitutional courts. I'm sure the experiences shared in this technical session has been especially helpful for the judges and advocates sitting in this conference and has reminded all of us in general to the contributions made by the various women in our day-to-day basis. On a day-to-day basis. Thank you, my lady.
Thank you.
With this, we come to the end of the first technical session. And we will now proceed for lunch. I request Honorable the Chief Guest, Honorable Judges of High Court with their spouses, former judges, resource person, and learned Advocate General to proceed for lunch at the Executive Dining Hall at Damodar Hostel. Volunteers are kindly requested to please assist. I now request advocates, law officers, nominated principal district judges and district judges, registry members, secretaries, senior government officials, and senior police officers, members of the press and media to proceed for lunch at Damodar Hostel Dining Hall. I request all the judicial officers who have been nominated for this conference and other officers and officials of Judicial Academy to proceed for lunch to cafeteria at the administrative building. I request all the nominated police officers, revenue officers, students of NUSRL, and other participants to proceed to the right side of the auditorium for the lunch. I also request all learned participants to join us sharp at 2:30 p.m. for the second technical session.
Check.
I request all learned participants to please take the seats. Welcome back to the second technical session of this conference on women's right to property, road to empowerment. The topic for the second technical session is women's right to property, rise in crime against women. I now request our chairperson, Professor Dr. Keshava Rao Borakula, Vice Chancellor, NUSRL Ranchi, and a speaker, Professor Dr. Mrinal Satish, Professor of Law, NLSIU Bangalore, to please come up on the dais. To chair the topic of today, we are honored to have with us the gracious presence of Professor Dr. Kesava Rao Varakula, Vice Chancellor, NUSRL Ranchi. Professor is the Vice Chancellor of National University of Study and Research in Law, Ranchi. Previously, he had served as the Vice Chancellor of Damodaran Sanjeevaya National Law University, Visakhapatnam. Sir has also held several other administrative positions, including that of Registrar of Chanakya National Law University, Patna. And Professor Rao has more than 4 decades of experience in teaching. He has participated in several national and international seminars and conferences and has authored many books and articles. He is an expert on evidence law, contract law, insurance law, and family law, and we at Judicial Academy Jharkhand are fortunate to have him here with us. To embark on a deeper discourse upon the topic, we have with us Professor Dr. Mrinal Satish, Professor of Law, NLSIU Bangalore. Professor Mrinal Satish is presently working as a Professor of Law at the National University School of India University, Bangalore, and he is a former chairperson of Delhi Judicial Academy. Professor Satish has been involved in various law reform initiatives. Sir was a part of the research team that assisted the Justice Verma Committee on amendment to rape laws. Sir assisted the 20th Law Commission of India on multiple projects involving criminal law and was part of a subcommittee appointed by the Law Commission to draft the 268th report on the Commission on Death Penalty. Professor Satish's area of interest and specialization is criminal law, and his research interest includes sentencing, gender and the law, reproductive justice, excessive under-trial and pre-trial detention. He has authored many books and articles, and it is an honor to have him here with us. I now request the chair to please begin with the session.
Professor Dr. Mrinal Satish, Professor of Law, National Law School of India, University of Bangalore, Honorable Judges present in this hall, respected judicial officers assembled, police officials present, revenue officials gracing this occasion, co-teachers of law, and my dear students, a very good afternoon to all of you. Hearty welcome to this session, the second plenary session on the topic, Women's Right to Property, Rise in Crime Against Women. Before we go to the topic, afternoon session in any one-day conference, that too after a very good lunch, is given a beautiful name. Some call it as yes, sleeping session. Some call it as DS, dormant session. And some great men called it as GYS. GYS, he gave a beautiful expansion. Graveyard session. Because according to his experience, not mine, any session after lunch will be resembling the atmosphere that will be found in a graveyard. Absolutely calm. Because everyone will be acting in some way or the other. Acting that they are listening, acting that they are comprehending, acting that they are understanding, and also exhibiting the fact that they are very keen to ask questions. But you know, acting is acting. So my job is to make sure that there is neither sleeping nor dormant nor any graveyard atmosphere in this session. I consider myself very lucky for this session because I have an expert here, Professor Dr. Mrinal Satish. He is the resource person for this session, therefore, most of the time he will be entertaining, enlightening all of us. Somebody told me that as a chairman, you will be considered successful if you remember two things. Number one, your presence must be felt, your voice must not be heard. It means I should not speak, I should make others speak. But at the same time, I should see that the dignity of the entire session is maintained by holding, that controlling stick in my hand. I don't have a stick, but I have a resource person. But he says, you please introduce the topic first. The essence of today's topic, especially this session, is rise in crime against women. It is on the presupposition that because of the right to property conferred upon women, there is a rise in crime against women. There is likely to be a rise in the crime against women. Either it is there or it is likely to be there. If it is there, what is to be done? If it is likely to be there, what is the course of action that has to be taken up? But the basic question is there a rise in crime against women because of the conferment of the right to right to property on women? If we actually take into account the statistics given by the National Crimes Record Bureau in 2021, total killings in India are 30,132 only is added by me. Out of the 30,132, females are 8,405. The figures I am placing before you are verifiable, straight away taken from the record of the National Crimes Bureau. Out of the 30,132 killings, the land disputes have contributed for killing of 2,488 persons. Unfortunately, the distinction between male and female among these 2,488 has not been made out. Therefore, we don't have the split figure. We only have a consolidated figure. When we are trying to figure out the rise of crime against women in relation to the right to property, naturally the motive for the crime should be, or the reason for the crime should be, property related matter. Now let me place a little bit of information before you. In 2019, 28,915 people have been murdered, out of which 9,765 related to property matters, land disputes, out of which specifically relating to property are 2,488, and family disputes led to the killing of 3,566. Well, this graph is always on the upward, it is never coming down. Well, if that is the case, we can safely say, though we don't have reliable researched information, that undoubtedly, if not significantly, there is contribution to the rise of crime because of right to property. Well, when we talk of right to property being conferred upon women, we are not supposing that the women doesn't have any right to property at all. Unfortunately, before the Hindu Succession Act came into force, and before even the Hindu Women's Right to Property Act of 1937 came into operation, there was law. And the law, unfortunately, can be described as having two basic features. Number one, the law was based upon impression. Number two, the law was based upon interpretation. What was the impression? The female members present here, well, I am sure you must have definitely followed what was said by Her Ladyship, Justice Nagaratnaji, that a female was considered incapable of managing property. Because she was considered incapable of managing the property, she was not conferred the right to have property on her own. In the sense, in some cases, female is given right to possess. In some cases, female is given right to enjoy. In some extreme cases, the female is given even right to alienate in case of legal necessity the property. But only in few cases, it is declared that a female's property will go to her own descendants after her death. The line of descent, right to descent, is unfortunately not available. This is because of two important reasons. Number one, at the time of Manu, there was a very simple principle. The property of any person on his death will go to his sapindas. One expression used is sapinda. But the whole question is, who is a sapinda? Sapinda is a person who shares the same particle of blood or body. Father and son, father and daughter, mother and daughter, brother and sister, they all share the same particle of blood. Therefore, they are falling under the category of sapindas, and therefore they are entitled to the share in the property. But unfortunately, there was also another school at that time which said sapinda means right to offer pinda. Pinda is offered after a person's demise. Therefore, whoever has the right to offer pinda is only entitled to claim a share in that person's property who passed away, in respect of whom he is entitled to offer pinda. This dichotomy in interpretation of the understanding of the word sapinda led to two different views. Two different views about what is the property of a female. At that time it was called Stridhana. Well, one great sage, Sanskrit writer by the name Yajnavalkya, who wrote Mitakshara on Manusmriti, has come out with a beautiful sloka. I recite it. Matrudattam, Pitrudattam, Bhatrudattam Dattancha Preeti Karmani Kadi Vedani Kadyanta Stridhanam Shadvigam Bhavet. Stridhanam Bhavet is conferred Shadvigam in 6 different sources or 6 different ways. Simple sloka. What is the first one? Matrudattam, gift given by mother. Second one, Pitrudattam, gift given by father. Third one, Bhatrudattam, gift given by brother. Fourth, Dattancha Preeti Karmani, gift given by anybody out of love and affection. Adi Vedani, at the time of recitation of Veda, Adyanta, etc. Sridharam Sadvigam Bhavet. This is the narrowest possible interpretation given to the wonderful expression Sridhara. Because if a female gets property from any other source, it is considered non-Sridhana. Non-Sridhana will not go to her relatives after her death. It will go back to the person from whom she got the property. It's called doctrine of reversion back. Now, property or gift given by mother, gift given by father, gift given by brother, gift given by any stranger, including husband out of love and affection, Adi Vedani. One person said, Vedam is recited on 2 different occasions. Number 1, when the female attains puberty. Number 2, when the female gets married. On these 2 occasions, whenever any property is given, a gift is given, it is considered her Sridhana. That is how the 6 sources have been identified. But then, if the female gets property from other sources, unfortunately, it is not considered as her Sridhana. But at that time, there was one Sanskrit Pandit whose name was Vignaneshwara. He came out with another beautiful interpretation. Adya Shabdena. See, in that sloka he has taken etc. Adya, Adyanta, etc. That Adya Shabdena Rikta, Kraya, Samvibhaga, Parigraha, Adhigama Praptam. He identified 5 different sources. Rikta, Kraya, Samvibhaga, Parigraha, Adhigama. If a female gets property from these 5 sources, it must be considered her Sridhana only, and after her death, it devolves upon her own relatives. Number 1, Rikta. In English, it means inheritance. Number 2, Kraya. It means property purchased. Number 3, Samvibhaga, property given to the female at the time of partition. Number 4, Adhigama, that is property which she got by adverse possession. She occupied for 13 long years and the law says you are the owner. And Parigraha as the first finder. If she is the first finder of the property, she occupied the property for 13 long years, she is given property on partition, she acquired property by money which she earned by exerting her own skill and intelligence, and then the property which she inherited. Any property that she got from these 5 sources must also be considered to be her Sridhana only. Sridhana Shabdam, he declared, Yaudhikaha. Sridhana is a beautiful word which is a scientific word, which must be given a scientific meaning. Na parivashakaha. It is not a common word which should not be understood in the common way like any other common word. It must be given a specific meaning. Unfortunately, in the male chauvinistic society that was prevalent at that time, this liberal interpretation given by Vignaneshwara has been challenged before the then highest court, the Privy Council. The Privy Council, very important case, the Buddha Singh case. Privy Council said, any property which a female gets from a male relative, any property which a female gets from a female relative, both cases, it will not be considered her Sridhana property. That means the entire liberal interpretation given by Vignaneshwara has been done. That means originally, whatever were the 6 important sources, only those sources were considered to be her property. In other words, only self-acquired property which she got a share from her father, she is entitled. Then what about the share in the joint family property? Joint family property, female has no role to play because female is not a co-partner. She doesn't have any right over the joint family property except right to be brought up, right to get married, right to maintenance after divorce, and right to die in the house. These are the only rights that were given. On this, the first important change was made in 1956 when Hindu Succession Act was passed. The idea of national partition was created, and if there is a daughter whose father was a member of the co-partnership, he died, he will be deemed to have died after making a partition, and whatever he would have got, it will be deemed to be self-acquired property, and because it is self-acquired property, she along with her brother is entitled to succeed to the property. This was the scheme. Now, because of this scheme, which was introduced, there was so much case law before the court. So many litigations have cropped up. Therefore, in 2005, they felt instead of giving a share in the property by imagining a national partition, let us simply declare her to be a co-partner, wherein the female will have a right to property in the joint family property also by birth. But unfortunately, if it is given a retrospective effect, a retroactive effect, naturally it is going to create a little bit of disturbance and disappointment in the mind of the people who have already had expectations. Now, when a brother and sister are there, the sister is married, the brother got the joint family property. Now, if the female who is a sister says, I am also entitled to share in the property, well, I am sure the females will agree with me. There will be very few brothers who are prepared to accept that stand, because it will be cutting into his own cake. Even if he is so large-hearted, there will be other members of the family who will not allow him to go ahead. This is the grand reality of what is happening. In such case, there is undoubtedly bound to be some rise in the crime against women. Therefore, any statute which is disappointing somebody and pleasing somebody is likely to create emotive feelings in the mind of the person who is disappointed, and sometimes when those emotions are not in control, it may lead to crime. And therefore, the statistics, if any proper research is made, we can always say, without any demur or any doubt, that undoubtedly the right to property which is conferred upon the women is likely one of the important features for rise in crime against women. With this observation, I will stop, and I now call upon our Chief Resource Person, Professor Dr. Mrinal Satish, to kindly speak about the crime against women.
Thank you. Thank you, Professor Keshav Rao, and I thank the Jharkhand High Court and the Judicial Academy and NUSRL for inviting me to this conference, and good afternoon to all of you. So the topic that I'm going to be speaking on is crime against women, and I'm not going to go into the conception of property as we have discussed all day today, but move away from that concept a little bit and try and understand where the conception of women as property led to increase in crime, one, and the second is the questions of interpretation. In the morning, we had a discussion where Justice Apresh Kumar Singh mentioned the decision of the Supreme Court in the case of Aparna Bhatt versus State of Madhya Pradesh, where he spoke about judicial stereotyping. I think that gives me a good foundation to say what I'm going to talk about going further. And Justice Endlaw then mentioned about the role of judges. So I'm going to bring both of that together and try and talk about the role of judges as conceptualized by the Constitution and the Supreme Court, and try and unpack how conceptions of property influence, conceptions of treating women as property influence adjudication or influence our thinking, and try and see what courts have said on that question as well. So to begin with, we have to look at what this word stereotyping means. Now, first let me read that definition and we'll try to take up examples. Stereotyping has been defined as categorization of individuals, often unconsciously, into particular groups or types, in part to simplify the world around us. The process of ascribing to an individual general attributes, characteristics, or roles by reason only of their apparent membership in a particular group. And a stereotype, against some authors define, is a generalized view or preconception of attributes or characteristics possessed by or the roles that are or should be performed by members of a particular group. In this view, a stereotype presumes that all members of a certain social group possess particular attributes or characteristics or perform specified roles. Now, let me use this example. So, all of us had lunch around half an hour ago. There was supposed North Indian food and supposed South Indian food. Now, I'm saying supposed because we have categorized food into North and South. Now, both of us were born in the south of the country and so are considered from the south. If I tell Professor Rao, you are South Indian, so you obviously like coffee and dosa, and I give him only coffee and dosa, when in fact, pardon me if this is wrong, in fact, he hates coffee and dosa, and he likes naan and sabji instead, and I force him to eat and don't have any other option, then that is a case of stereotyping, because I have said he's South Indian and so therefore given him South Indian food.
I have no option but to like the coffee and dosa made by my wife.
So, for instance, give you a personal example. When I first, I went to Delhi for an internship when I was a student, and I was staying in some place, and so I went to visit a friend's house. And the friend's father said, I have made a reservation in one of the top South Indian restaurants in Delhi, because obviously you're missing South Indian food. Restaurant was good, but if it wasn't and I couldn't say anything, I would have to have that food. Bihar and Jharkhand are good examples, because there's so many stereotypes surrounding Bihar and Jharkhand that people, it works to the disadvantage of people from Bihar and Jharkhand, because you say, oh, you're from Bihar, so therefore there's some sort of understanding of people. So that is stereotyping. So it's convenient, because I don't have to then think of what I need to serve Professor Keshav Rao when he comes to my house. South Indian, so I just order dosa and coffee. It's convenient, like it says, socially. But as we move to law and adjudication, do these stereotypes then start becoming a problem and impact people in particular ways? And that's what I'm going to try and look at. So this is, again, something that happened, I think, a couple of months ago, when the noted actress Alia Bhatt announced that she was pregnant. Now, this Pink Villa website or newspaper, whatever it is, said this, said actress Alia Bhatt took the internet by storm on Monday morning after she announced her first pregnancy. Reportedly, the mommy-to-be will return. She was in London at that time shooting, or in the US shooting for a movie. Reportedly, the mommy-to-be will return to Mumbai in mid-July. It is also being reported that Ranbir might go to the UK to bring his wife home. According to India Today, Alia will be taking a rest after she returns from a shoot. The report also suggests that the actress planned her pregnancy in a way that doesn't affect any of her commitments. She will be wrapping up her films, Heart of Stone and Rocky or Rani Ki Prem Kahani, before the end of July. So this is what the newspaper reported without asking Alia Bhatt what her plans were. So she responds on Instagram, as she says below, meanwhile, we still live in some people's head. We still live in some patriarchal world. Nothing has gotten delayed. No one needs to pick anyone up. I am a woman, not a parcel. I do not need to rest at all, but good to know you all have a doctor's certificate as well. This is 2022. Can we please get out of this archaic way of thinking? Now, if you could excuse me, my shot is ready. Right? So this was a classic example of a newspaper putting out something about Alia Bhatt, saying she's going to take rest, Ranbir is going to go pick her up, and all of these things, to which she reacted. And again, this is a stereotype of looking at her in a particular way. The other big thing is, I many of you might have heard of Samantha Ruth Prabhu, famous actress again. Uh, Frankly, I don't watch too many movies from the South, and so I wasn't familiar who she was. Until suddenly, everywhere you looked at was talking about her divorce from her husband, his name Naga Chaitanya Akineni, right, son of Nagarjuna. And everything was about her, why she had gotten divorced, this must happen, that must have happened, stories after story every day. And then someone put this out. Samantha Ruth Prabhu is a divorced, ruined, second-hand item who has 50 crores tax-free money robbed from a gentleman. Now, why I put this tweet out is when someone asked her what hurt you the most, she said amongst everything that happened, this tweet was the one that hurt me the most because of course, it is not true. The 50 crore was supposed alimony that he had paid her. And so again, looking at someone saying that, there's something wrong with her because she divorced her husband, so it must be her fault, and it was her fault, and she also got 50 crores in the process. So these are again examples that are happening around us of stereotypes. Now, I'm going to now place this in the context of rape law to try and look at how stereotypes, and this is an area I work on, which is why I'm using it, to see how stereotypes impacted rape law and what the Justice Verma Committee, in its recommendations nearly 10 years back, said on this issue. So this we have dealt with. So what are stereotypes that are said about the offense of rape? Some of these are still used, some fortunately no more. So calling rape accused as monsters, beasts, animals, etc. Now this is also a stereotype. I'm not talking about the accused victim here, but about the accused. Now it's called the concept of othering. If you start saying, oh, someone who commits an offense is a beast, a monster, an animal, you are saying people like you and me will not ever commit an offense. And that, as again Professor Keshwara was giving us the statistics, in most crimes, especially in sexual crimes, the person who commits the offense is known to the victim. So therefore saying it cannot be one of us is a stereotype. Similarly, you have acquaintance rape is less traumatic than stranger rape, a requirement that the offense be reported immediately, which of course the Supreme Court nearly 25 years back said is not required. But that was built on the assumption that unless you report promptly, it means the offense is false, it has not been committed. So there are a set of these stereotypes. So here I'm giving you judgments of the Supreme Court which are positive. Positive in the sense the ultimate conclusion reached by the court is something that is within the realms of the law and the Constitution. But what does the court say? The first one is a 1980 judgment of the Supreme Court, which says when a woman is ravished, what is inflicted is not merely physical injury, but a deep sense of some deathless shame. So the stereotype here is the understanding that rape leads to shame. Now, as I said earlier, when I used the dosa example, it might be that Professor Keshav Rao loves the dosa. So that's fine. So there may be people who feel shame. That's fine. But if I tell him you have to love the dosa because you're South Indian, then what that does is that it makes the law here expect a certain type of behavior from a person. So therefore, if you say that there's a requirement of feeling shame, there's a problem. And as I go later on, I will show you how that impacts adjudication as well. The second is a sentencing decision in the case of Madan Gopal Kakad versus Naval Dubey. This was a case of child sexual abuse. The girl was 8 years old at the time of the abuse by the accused Naval Dubey. And the court was sentencing him after convicting, this Supreme Court. And the court says, we are told at the bar that the victim, who is now 19 years old, the case had dragged on for 11 years, after having lost her virginity, still remains unmarried, undergoing the untold agony of the traumatic experience and the deathless shame suffered by her. Evidently, the victim is under the impression that there is no monsoon season in her life and that her future chances of getting married and settling down in a respectable family are completely marred. So this was the rationale that the Supreme Court used to impose sentence on the accused. Like I told you earlier, the victim was 8 years old at the time the offense was committed. That itself was an aggravating factor, but that's not the factor that the court uses. The court uses the fact that there's agony, there's shame, she's unmarried, she must have lost chances of getting married as a reason to impose the sentence that it does. Then you have a case of state of UP versus Chotelal, where the court said the important thing that the court has to bear in mind is what is lost by the rape victim is face. She loses value as a person. Right? Again, I said all of these cases are convictions, these are not acquittals. So the court is saying a woman loses value as a person because of the offense of rape. State of MP versus Madan Lal is a case where the Supreme Court said that you cannot have compromise in cases of rape. And the reasoning that the court uses is the body of a woman is her own temple. Reputation is the richest jewel one can conceive in life. When a human frame is defiled, the purest treasure is lost. There cannot be a compromise or settlement as it would be against honor, which matters the most. Now again, this is the thought of the judge at that point of time, but to students of law, the fact that section 320 of the CRPC does not permit compounding is what should be the legal reason, not this that the court has used in this case. So the offense is conceptualized as a crime against honor, chastity, virginity, and questions of marriage. Now, if we step back a bit, we have this case of Barwada Boginbai Hirjibai versus State of Gujarat, 1983, volume 3, SEC, page number 217. This is one of the most cited cases in the context of rape law because of the fact that the court in this case gave reasons as to why an Indian woman will not lie about being raped. I'm not going, for lack of time, I'm not going to go through what it said, but it gave 12 reasons on the basis of which it said an Indian woman will not lie about being raped, which is why her testimony should be accepted in court. Now, because of the fact that there's a summary of reasons, this case starts getting cited in all cases where questions of the testimony of the victim comes in. And as I mentioned to you earlier, when we speak about the agony, as you know, section 218 the CRPC requires judges to note the demeanor of the witness. So in the context of demeanor, does it then matter that the woman does not look shocked or that she does not look traumatized, and does that impact the process of adjudication of appreciation of evidence? So for instance, in the Supreme Court judgment of Kamalananta versus State of Tamil Nadu, 2005, 5 SEC, page number 194, the Supreme Court, so this was a case of murder, rape and murder, rape of a few women in the so-called Godman had an ashram where he was raping multiple women who were there, and he had killed his secretary who figured out that this was happening. And so this is again a case of conviction. But what the Supreme Court does in this case, it says that, look, as these witnesses were testifying, all these young women were testifying, they were crying, somebody was fainting, somebody required water. And so therefore, that is why we are believing the testimony of these young women. Again, as students of evidence, we would say that that can't be the reason why you're believing the witness. It has to be something else. So question of demeanor comes into it. Then there's also questions of medical evidence. Now, if you look at the history of medical evidence, a lot of these stereotypes, I'm just again going to skip some of this, a lot of these stereotypes have come into medical evidence, right? So again, all of you will be familiar with the Modi's textbook of medical jurisprudence and toxicology. Now, if you look at the history of Modi's medical jurisprudence, like I have a bit in the previous slide, it is taken predominantly from colonial understanding of Indian behavior, right? So as you know, as students of history, the British just could not understand Indians. Why was it that people from one part of the country were traveling to another part of the country during some seasons? Why is it that they all get together in one place? Why? And of course, this entire thing of snake charmers, elephants, etc., etc. And so therefore, they said, okay, Indians are all liars, right? Indians will lie in court. And so therefore, we need to completely look at scientific evidence in matters involving Indians. And anyway, there was in the 19th century disbelief of women. So if like one of the speakers mentioned in the morning, in the question of intersectionality that comes in, if you are an Indian woman, the chances of your being believed in court was virtually nil. So therefore they said we should figure out medical evidence. So if you look at medical evidence, there is that fourth bullet point in the second, lack of injuries. Dr. Modi in his book said it is not possible for a man to single-handedly rape an adult woman, right? Now where he came up with this from, you don't know, but courts accepted it. You had judgments after judgments which said it is not possible for a man to single-handedly rape an adult woman. In fact, the Orissa High Court in 2004 said this in a judgment. And in 2008, Justice Arijit Pasayat in the Supreme Court, in this case of Sukru Gowda versus State of Orissa, 2009 to SEC 118, says, we do not know where the High Court got this view from. Right? So they actually pulls up the High Court judge for using that term. The High Court had got it from Modi's medical jurisprudence. But so you can see how stereotypes come into medical jurisprudence as well. So when the Justice Verma committee was looking at making changes to the rape law nearly 10 years back, the main recommendation that the committee made was that you take offense of rape outside the chastity, virginity, shame framework. And this framework had come in because of the understanding of women as property. So that's what the committee said. Don't understand women as property and don't make your interpretation based on that. You have to take this out and you have to think of it in the context of the Constitution. So you constitutionalize violence against women and look at questions of bodily integrity and sexual autonomy. Now this was 2012-13. The Supreme Court in multiple cases thereafter has recognized both sexual autonomy and bodily integrity as part of Article 21 of the Constitution. Most importantly, in the case of Justice Puttaswamy, where the Supreme Court, the 9-judge bench has accepted this bodily integrity and sexual autonomy as a part of Article 21. So the focus of the 2012-13 law reforms was on, like I mentioned, on sexual and bodily autonomy of women and protection of their constitutional rights, and on improving access to the legal system, which I think what's going to be discussed in the next session, and amendments were accordingly suggested. Now, there are some questions that have come up in the context of this issue of autonomy. One is Section 19, 20, and 21 of POCSO, the question of mandatory reporting in the POCSO Act. As was mentioned in the morning as well, Justice Nagaratna mentioned that the judgment of the Supreme Court last week in the context of reproductive autonomy, in the context of abortion, where the Supreme Court has now said that if mandatory reporting may lead to safe abortion services not being provided to women, to young women under the age of 18, then we'll read down the mandatory reporting provision to that extent. So therefore, that part has been taken care of now by the Supreme Court judgment. The other question is of marital rape. The question of marital rape again comes back to understanding of women as property. The justifications that have been given not to criminalize marital rape have been on the understanding that women are the property of men. There is a question of the theory of unification, where when once married husband and wife become one unit, etc. So those questions which the Verma committee had also dealt with and said that that marital rape should be criminalized because of the fact that these justifications don't hold anymore. So I want to now move on to stereotypes in adjudication and the role of courts. Here I am picking up this judgment of Air India versus Nargish Mirza. This was again the Supreme Court in, which I'll talk later on, both in Nautej Johar and Joseph Shine more recently, has shown a light on the reasoning used in Air India versus Nargish Mirza. Now, if you look at Air India versus Nargish Mirza, if you remember, again, the important constitutional law case where air hostesses who were employed with Air India had to retire at the age of 35. So the Supreme Court had to determine whether the retirement policies of Air India were discriminatory towards women. So Air India's service regulations provided that air hostesses would retire at the age of 35, whereas male pursers would retire at the age of 58. Now, Air India's justification for that policy, which is in yellow, was that air hostesses are recruited for providing attractive and pleasing service to passengers in a highly competitive field, and consequently stress is laid on their appearance, youth, glamour, and charm. So the court dismissed this argument and held such a morbid approach is totally against our ancient culture and heritage, as a woman in our country occupies a very high and respected position in the society as a mother, a wife, a companion, and a social worker. So this was the Supreme Court's reasoning there. Right? So in the case of Navtej Singh Johar, Justice Chandrachud in his judgment, now goes back to the reasoning in Air India versus Nargish Mirza and says this in paragraph 80. He says the regulation permits an air hostess to marry at the age of 23 if she has joined the service at the age of 19, which is by, no again, so this was the other challenge in that the regulation said that if the woman got married between 19 and 23, she would lose her job. So here Justice Chandrachud is quoting from that paragraph, which is by all standards a very sound and salutary provision. So what the court said, Supreme Court in Nargish Mirza, said that, look, this is good because this helps in the family planning program of the country, because if the woman is not married in those 4 years, she won't have a child, and then she'll be more mature to take care of the child, etc. So that's the reason on which it did not strike down that provision. So in Navtej Singh Johar, Justice Chandrachud in paragraph number 437 says this. He says a strong stereotype underlines the judgment. The court did not recognize that men were not subject to the same standards with respect to marriage. It holds that burdens of health and family planning rest solely on women. This perpetuates the notion that the obligations of raising family are those solely of the woman. In dealing with the provision for termination of service on the first pregnancy, the court opined that the substituted provision for termination on the third pregnancy would be in the larger interest of the health of the air hostess concerned, as also for the good upbringing of the children. Here again, the court's view rested on a stereotype. The patronizing attitude toward the role of women compounds the difficulty in accepting the logic of Nargish Mirza. This approach, in my view, is patently incorrect. So therefore, the reasoning that the Supreme Court used in Nargish Mirza, that we are going to strike down the provision because a woman holds a particular role in society, Justice Chandrachud says that that reasoning is based on a stereotype, and we cannot use that sort of reasoning in judgments. More recently, a couple of months back, we have this decision of Aparna Bhatt versus State of Madhya Pradesh. This judgment is very important because of the fact of what the Supreme Court talks about role of courts in the context, and everything that's been discussed in the morning. Some of this is in this judgment. So I'm going to quote from a few paragraphs. I think it's very important for us to keep these paragraphs in mind. It says the role of all courts is to make sure that survivor can rely on their impartiality and neutrality at every stage in the criminal proceeding where she is the survivor and an aggrieved party. Even an indirect undermining of this responsibility cast upon the court by permitting discursive formations on behalf of the accused, that seek to diminish his agency or underplay his role as an active participant or perpetrator of the crime, could in many cases shake the confidence of the rape survivor or accuser of the crime in the impartiality of the court. The challenges Indian women face are formidable. They include a misogynistic society with entrenched cultural values and beliefs, often subconscious, about the stereotypical role of women, social and political structures that are heavily male-centric, most legal enforcement structures that either cannot cope with or are unwilling to take strict and timely measures. Therefore, reinforcement of this stereotype in court utterances or orders through considerations which are extraneous to the case would impact fairness. Then Justice Bhatt, writing the judgment, goes on to say, judicial stereotyping refers to the practice of judges ascribing to an individual specific attributes, characteristics, or roles by reason only of her or his membership in a particular social group, example, women. It is used also to refer to the practice of judges perpetuating harmful stereotypes to their failure to challenge them, for example, by lower courts or parties to legal proceedings. stereotypes excludes any individualized consideration of or investigation into a person's actual circumstances and their needs or abilities. Judges can play a significant role in ridding the justice system of harmful stereotypes. They have an important responsibility to base the stereotype of the ideal sexual undermine the credibility of those women who are seen to behaving a certain way, reporting the offense immediately, etc. So therefore, this court holds that use of reasoning language which diminishes the offense and tends to trivialize the survivor is especially to be avoided under all circumstances. Thus, the following conduct or actions or situations are hereby deemed irrelevant. Right? So then the court lists out a series of things which it says it's irrelevant and says again that this is an illustrative list. The court then says the instances spelled out in the present judgment are only illustrations. The idea is that the greatest extent of sensitivity is to be displayed in the judicial approach, language and reasoning adopted by the judge. Even a solitary instance of such order or utterance in court reflects adversely on the entire judicial system of the country, undermining the guarantee to fair justice to all, and especially to victims of sexual violence of any kind, from the most aggravated to the so-called minor offenses. Further, courts should desist from expressing any stereotype opinion in words spoken during proceedings or in the course of a judicial order to the effect that women are physically weak and need protection, women are incapable or cannot take decisions on their own, men are the head of the household and should take all decisions regarding to family, women should be submissive and obedient according to our culture, good women are sexually chaste, motherhood is a duty and role of every woman, and assumptions to the effect that she wants to be a mother, women should be the ones in charge of their children, their upbringing and care, being alone at night or wearing certain clothes make women responsible for being attacked, etc., etc., right? So, so the Supreme Court is now saying that the court should desist from expressing any stereotype opinion in words spoken during proceedings or in the course of a judicial order. So, court, and again, the court gives us an illustrative list of things that are not permissible both in judicial orders as well in spoken words during judicial proceedings. So this is important for us to keep in mind as we move along, as the Supreme Court has moved a long distance from where it was, as I showed you in judgments the 80s, to what's happened just earlier this year. I'm going to conclude with the last set of points, again this because of the decision of the Supreme Court last week in the context of abortion. Now, I'm not going to talk about that decision in particular, but I want to focus on the stereotype again here that led to some of the understanding on the Medical Termination of Pregnancy Act, which the Supreme Court discusses in the judgment last week. Now, one of the stereotypes again is that women are not capable of making healthcare decisions for themselves. So therefore, tendency of doctors in a lot of situations to say, but is your husband agreeable to what you're proposing? So Section 3, again, Supreme Court last week mentioned Section 3 of the MTP Act, says that, as you know, the IPC criminalizes abortion. The MTP Act creates an exception to the IPC, Sections 312 to 318. Now, the MTP Act says that the consent of the woman has to be taken before terminating her pregnancy, and it is her and her alone. You don't need to take consent of any other person. But there were consent of the spouse. Now, the spouse went to criminal court against the doctor, saying that you should have taken my consent before terminating the pregnancy. Now, the Punjab and Haryana High Court said that was not what the MTP Act required, and therefore there was no wrongdoing on the part of the doctor in terminating the pregnancy without the consent of the husband. This went on SLP to the Supreme Court. The Supreme Court dismissed the SLP, noting that the judgment of the Punjab and Haryana High Court was based on proper reasoning, so they didn't even hear the case on merits. Then you have another important case, which is Z versus State of Bihar. This reported in 2018, 11 SCC, page number 572. Here again was a case which arose from Patna, where there was this destitute woman who was found on the streets, turned out to be pregnant. Tragic case because the hospital, the doctors, and even the High Court tried to find her husband in order to get his consent to terminate the pregnancy, by which it got too late. And by the time the case reached the Supreme Court, there was but for the woman to deliver. The woman unfortunately died thereafter, and the Supreme Court in this case awards compensation of rupees 10 lakhs to be paid to the woman, saying that this question of spousal consent is not required. It's the woman's sole decision to decide whether she wants to terminate the pregnancy or not. So this is ex versus principal secretary. There's again 2 decisions from the Supreme Court earlier last week and a couple of months ago, where the Supreme Court is now holding that some of the rules that were brought out in the MTP rules last year, which made a distinction between married and unmarried women, are not constitutionally tenable. So therefore, if abortion services are available to married women, it should be available to unmarried women as well. So I want to now finally conclude by talking about implicit bias. Now I know we talk about biases which are explicit, right? When you interrogate, you question whether there's a bias there, it's evident, it's visible, right? So explicit biases are consciously accessible through introspection and endorsed as not appropriate, right? But implicit biases are ones that are not consciously accessible, right? We may have them. If we think that we are biased, we might say, no, we are not. I'm not biased in this way. But it's natural for us as human beings to have biases and prejudices. So therefore, in the context of implicit bias, the important thing to keep in mind is, because these biases, again, I'm going back to stereotyping, since these biases might be unconscious, we have to be aware of the fact that we may have implicit biases, and we should take that in mind, keep that in mind when we are making any decisions. And the last point is, we have an oddly stubborn tendency to anchor to numbers, judgments, or assessments to which we have been exposed, and to use them as a starting point for future judgments, even if those anchors are objectively wrong. Right? So therefore, again, that in decision making, anchoring is something that is understood this way. That so our implicit biases in the context of anchoring is something that we have to be conscious of, and like the Supreme Court has said in the case of Aparna Bhatt, to be careful that we don't bring those stereotypical understandings into our decision making. So I'll stop there and hand back to Professor. Thank you.
Thank you very much, Mrinal, for clearly pointing out 2 things that must be taken care while dealing with either cases relating to property or cases relating to crime due to property matters. Stereotyping is to be avoided, and anchors on which most of the judgments are based, most of the judicial reasoning is based and approach is based, must be avoided. By way of conclusion, there is a stereotyping going on now also. And whenever the topic women's right to property is discussed, we also follow a stereotyping. We only discuss about the availability of the right. We never talk about the equality of the right. We also confine ourselves only to inquire whether a Hindu woman's right to property is available or not, except referring very tangentially to the right of a female Muslim and a female Christian right to property. Well, I'm sure those of you that have followed the narrative made by Her Ladyship, Justice Nagaratna ji, while discussing about women, she said, there is disparity and no equality even if right is there in the share of property a son and a daughter gets, a share of property that a father and mother gets, though they are equal, but the share of property in Muslim law is not the same. We are content with the stereotype of discussing is there a right or not, whether it's an equal right or not, we never bother. And mostly we confine ourselves to Hindu law. From the time of Manu to modernity and to future, we will always discuss about the right to property only. Well, as far as Hindu law is concerned, there was a beautiful saying for the state of affairs that it has gone through for the past so many centuries. It was said, Hindu law was made by Sanskrit Pandits who do not know law. And Hindu law was interpreted by advocates and judges who do not know Sanskrit but only know the law. So when such a wonderful combination comes, there is bound to be confusion. And English people in their wisdom felt better not to meddle in this confusion, leave it to them. So they said, we are not going to touch the personal laws. Therefore, it took so many years to come out of the rut and to proclaim today that either in the self-acquired property or the joint family property, female is having a right on her own individuality, not depending on somebody. Now, friends, what is to be done now? One thing is certain, if a research is undertaken ever since 2005, you will definitely find two important things. Number one, crimes against women are increasing. And number two, one of the important reasons for the increase is undoubtedly disputes relating to property, whether it is succession or inheritance, this matter. When these two are there, how to make sure that the women are not subjected to such crimes? Well, already we have two beautiful sections in Indian Evidence Act, Section 113A and Section 113B, which virtually reverse the presumption or reverse the burden. They have reversed the burden, and instead of placing the burden on the prosecution, they have reversed the burden and placed it on the accused. Now, I am sure an intellectual body like this should consider whether such a omnipotent reverse burden clause is essential for safeguarding the women in respect of crimes that may be committed against them due to the conferment of right to property, both in separate self-acquired property of her relatives as well as her own property, and then the joint family property. This is one thing that must be undoubtedly undertaken, besides the research whether really there is increase in crime rate because of the conferment of right to property on the female. Another important area which must be considered is if a par with the male, that is the son, if we have to progress from patriarchy to parity, then retrospectivity is undoubtedly an important element. If retrospectivity is an element, then what are going to be the consequences? Unfortunately, in India, we lay down the law first and then try to understand its consequences. Populism is one of the important sources for reasons for laying down the law, and then leave it to the courts as and when the matters come before it. It is for the courts to resolve it. It is never thought over in a systematically, in a scientific fashion before actually making the 2005 amendments. By declaring it, it is retroactive or retrospective in nature. This is another aspect which must be considered. And if we take the theme of this entire session into account, women's right to property need to be conferred, is conferred, will continue to be there. In all probability, within a few years to come, there may be equality irrespective of the religion to which the female belongs. But at the same time, it is also going to throw certain problems like retrospectivity, like equality, and one must be equanimous in ensuring. I thank all of you for demonstrating that you are here, not only physically, but I'm sure, hopefully, psychologically. And on behalf of all of us, I thank Mrinal for advising us, cautioning us the consequences of being stereotyped and sticking to the anchors that are already there. And let us see how best we can ensure that conferment of one right does not result in another disadvantage to a female. Well, with this caution, I thank every one of you for the hearing and to the organizers for the opportunity given and to him for the wonderful presentation. Thank you.
If our resource persons may permit, there are certain questions from the participants that I would like to put on their behalf. One of the questions that has come is that can a Hindu daughter have right of inheritance if she gets married to a Muslim or Christian under the Special Marriage Act?
In case people get married under the Special Marriage Act, the Indian Succession Act will apply, and Indian Succession Act confers right both on a male and a female, both on a son and a daughter, both on a father and mother, without any problem.
The next question would be, what is the right in the property of stepmother if it is a self-acquired property of the stepmother?
Stepmother.
Yes, sir.
Very, very interesting question. Mother is a mother who gives birth to the son. Stepmother, I'm sure she has brought up the child, but she is not the mother. Therefore, when somebody is not the mother, I have to be at the grace of that person and I cannot claim any right on my own merit. So, according to me, I have no right to claim property of a share in the property of my stepmother unless she gives me graciously.
The third question would be, sir, that when can a girl claim partition from the property of a maternal grandfather?
Maternal grandfather, the girl wants a partition of the property. Well, number one, the girl has no right to demand partition even in the property of her own father or mother, unless it is a joint family property, in which case only father's property she can claim partition. Therefore, when she can't claim from her own mother, where is a question of claiming from the maternal father of the, maternal grandfather? Out of question. There must be some limits for dreaming also.
Thank you. Thank you, sir. I thank both our esteemed professors in providing a deeper awareness on the topic.
Why are you so partial? You are not asking me any question. Ask him one question. On your own, when nobody asks, you have to be ready with some questions.
Yeah. If sir permits, there are questions on inheritance law.
Inheritance, you will answer, otherwise I'll answer, don't worry. Please go ahead. Shoot, otherwise he will feel unhappy. Equality before law, at least the semblance must be there.
So whether a female can get the property of a father-in-law or grandfather-in-law if her husband is alive.
Husband himself can't get. Where is the question husband's wife trying to get? Somebody who is asking the questions must be having grand plans. But let me tell you very honestly, most of the time the grand plans won't make us succeed. Some plans better remain as plan only, because if they unnecessarily create expectations, expectations lead to disappointments, disappointment leads to disaffiliations, and disaffiliations may result in disputes, and disputes may result in either a tort or a crime, which neither is advisable. Sir? No harm in dreaming, yes, sir. Well, definitely no harm in dreaming unless it is a daydream. Okay.
Thank you, sir, for highlighting how stereotypes, biases, and other factors have contributed to the rise in crime against women since ancient times. Thank you so much, sir. With this, we come to the end of the second technical session. We now come to the third and the final session of this conference, and the topic of this session is right to property, strengthening access to justice for women in India. To deliberate on the topic, we have with us two eminent guests, Ms. Kanta Singh, Deputy Country Representative, United Nations Women India, Delhi, and Dr. Mrs. Vandana Singh, Advocate, High Court of Jharkhand, Ranchi. I request both madams to please come on the dais. Ms. Kanta Singh is the Deputy Country Representative of UN Women India. She is a seasoned development professional with over 20 years of multicultural experience. She has led several national programs on education, employment, and entrepreneurship for women and girls while working with UN Women. She has also rendered policy advice to the center and state governments on issues involving women in India. We are fortunate to have such an avid advocate of gender justice here with us. Dr. Vandana Singh is serving as a Senior Standing Counsel for the state of Jharkhand since June 2020. She is also an empaneled advocate with Khalsa. She has nearly 2 decades of experience at the bar and is passionate about women and child rights and has written custody, tribal women empowerment, etc. She is an expert in matters relating to constitutional law, service law, and criminal law. We at Judicial Academy Jharkhand are fortunate to have both of us here with us. I request Madam to please begin with the session.
Thank you very much. Good afternoon, everyone. It's been a really wonderful day. I'm really proud and privileged to be sitting here amongst all of you and represent UN Women India. Just before I start, I'd like to share what we do as an agency. We are a specialized agency of the UN system. We look after the interests of women. We represent their issues. We also work very closely with the central and state governments. Before joining UN Women in 2019, I used to work with the UNDP. For almost 10 years, I worked there. And through a project called Access to Justice for Marginalized People, I worked very closely with State Legal Service Authority here in Jharkhand and did some good work I can claim now. The work with paralegals, work with the common service centers, the kiosks in the courts, some of those things were done by us. Good part about that program was that those initiatives have been scaled up by Department of Justice, Government of India, and now UN is out of that. But next year, hopefully, we'll start a program again for access to justice for women. And Jharkhand will be one of the states, I am hoping. मैंने सुबह से बहुत अंग्रेजी सुनी, मेरी प्रैक्टिस भी ख़त्म हो गई. सो थोड़ा भाषा का परिवर्तन करते हैं, क्योंकि यहाँ पे बहुत सीनियर जजेस बैठे हैं. मैं सबसे पहले अपनी तरफ से ये कहना चाहूँगी कि कुछ अगर गलती हो जाए, कुछ गुस्ताखी हो जाए तो मुझे माफ़ कीजिएगा. आई एम नॉट अ लीगल पर्सन. मैं क्योंकि जजेस के साथ काम किया है 6, 7, 8 साल तक लगातार, तो थोड़ा बहुत जानती हूँ, लेकिन भाषा आप लोगों की नहीं जानती हूँ. तो कोई भी गुस्ताखी हो तो माफ़ कीजिएगा प्लीज़. दूसरी बात ये कि थोड़ा सा अगर मैं भाषा को मिक्स करूँ तो आई होप दिस नोबडी हु डजंट अंडरस्टैंड हिंदी एट ऑल. कोई ऐसा तो नहीं जिसको हिंदी बिल्कुल नहीं समझ में आती? तो कैन आई मिक्स द लैंग्वेज? वंडरफुल, थैंक यू। मुझे अच्छा लगा जब प्रोफेसर मरनाल ने बात की क्राइम अगेंस्ट वुमेन की, पर्टिकुलरली रेप लॉ की। मेरी ज़िंदगी का सबसे प्रोफाउंड एक एक्सपीरियंस मैं आप लोगों के साथ शेयर करना चाह रही हूँ। जब तक आप अगर नहीं बोलते उसके बारे में तो मैं शायद इतनी हिम्मत नहीं कर पाती, लेकिन अभी मेरी हिम्मत हो रही है तो मैं ज़रूर शेयर करना चाहूँगी। When I started my career as a gender trainer, my first assignment was to train the judges. And trust me, I was completely ill-equipped. I didn't know how to even speak to judiciary. We were in Chandigarh. There was a judge from Sweden, a lady, retired lady judge. So we were talking about sexual offenses against women. We were talking about child sexual abuse. So very difficult topics to talk. And some people from the judiciary were talking कि नहीं मैम ऐसा नहीं होता है, होता ही है हमेशा। In gender trainings I have seen that first half always goes in discussion denying that something like this doesn't happen. अब थोड़ा सा और acceptance है, उस वक्त I'm talking about 30 years back, it was slightly easy, more difficult I would say to talk about these issues. So उस जज ने एक काम दिया सभी को, जो ऑडियंस में जो पार्टिसिपेंट्स थे जो उस ट्रेनिंग के, उन्होंने कहा मुझे 2 वॉलंटियर्स चाहिए। Why I am narrating this incident is that it's very useful for everyone who's sitting in the room, all duty bearers. So she said, मुझे 2 volunteers चाहिए. Judges being judges, they were not ready to come forward. Nobody came forward. Then she picked up 2 people from the participants list. So उन्होंने कहा कि अपनी ज़िंदगी का सबसे खूबसूरत सेक्सुअल एक्सपीरियंस शेयर कीजिए मेरे साथ, जो आपके दिल के बहुत करीब हो। Now there was deathly silence there, and you all can imagine why. We don't talk about these issues so often, particularly our own personal experiences. So जब कोई भी नहीं बोला तो उन्होंने कहा नहीं, I insist that you speak. तो बहुत धीरे धीरे किसी ने कहा, yes ma'am, it was with my wife, it was nice, we felt good. And she said, do you know a 14-year-old girl, when she goes through rape, how from police investigator to judges to medical authorities, what kind of questions do you ask the girl? और कितनी बार, 4 बार, 5 बार, कहाँ छुआ, क्या पहना था, आपने क्या कहा, आपने मना किया कि नहीं किया? She said, how painful, I still have goosebumps. Every time I narrate this incident, I really feel very hurt. वो मेरे लिए personally as a trainer, I thought that was very powerful thing she did. हम शायद वो नहीं कर पाते. So thank you, Professor Manal, for starting this discussion. I'm also very happy about, and this is for all of you to think how sensitive we are when we are dealing with cases of sexual offenses. Asking a girl to explain everything again and again and again. Let's not do that. And I think there have been some changes after that in the last few years, that judges have started taking more precautions in in-camera recordings and all those things. So I'm hoping that things will improve. Property rights for women. This issue is very, very close to my heart personally, because I work a lot on women's economic empowerment, because I believe that without women's economic agency, everything else that we do, particularly as an agency, is not as relevant, not as effective. मुझे ऐसा लगता है पुरुषों में महिलाओं में सिर्फ एक बेसिक फ़र्क है, other than our biological difference, is that you own and we don't. Have-nots का जो फ़र्क है वो सबसे पहले हम महिलाओं और पुरुषों में देख सकते हैं. I still remember as an 8-year-old girl, मैं खेती वाली फैमिली से आती हूँ जहाँ हमारे घर में ज़मीन है, भाई हैं, हम बहनें हैं, लेकिन माँ बहुत साधारण तरीके से ये कहती थी, इतने किले हैं, किले हमारे हरियाणा में से हूँ मैं, तो बहुत किले बोल देते थे, इतने किले हैं, इतने भाई हैं, इतने इतने आ जाएंगे. As an 8-year-old girl, you don't have the concept of marriage. You don't understand आप कहाँ जाएंगे, मतलब मेरा क्या है इस घर में. So do you get the loss of agency even at that young age, that nothing in this house belongs to me. अब माँ ने जो देखा है, सुना है, माँ वही कह रही है. Every girl is prepared for marriage. Every boy is prepared for career, earning money. हमें 8 साल की उम्र में नहीं पता चला कि हम कहाँ जाएंगे. शादी का तो कुछ समझ में नहीं आता था, या हमारा इस घर में है क्या. So, जब इतनी लॉस उसके साथ हम लोगों को बड़ा किया जाता है, लड़कियों को, बड़े होके हमसे ये उम्मीद करना कि हम ज़मीन के लिए लड़ाई करेंगे, ये बहुत मुश्किल काम है, बहुत ही मुश्किल काम है. So, आज के दिन स्थिति क्या है? Why are we talking about property rights here? Why it is so relevant, why it is so important for all of us to know that firstly, women exist. Secondly, they have equal rights as have been guaranteed by our constitution. Number 2. Thirdly, it is also very important not to just have rights, but also to realize those rights. अगर 75 years of independence के बाद भी दुनिया भर में बात छोड़ के हम सिर्फ इंडिया की बात करें तो दो डेटा बहुत रिलायबल नहीं है, बट 11 से 12% महिलाओं के पास प्रॉपर्टी है. तो दुनिया की 90% प्रॉपर्टी, जनरली ग्लोबल ट्रेंड्स भी यही कहते हैं, ग्लोबली 17-18% कहते हैं, इंडिया में अगर 11% है तो 89% प्रॉपर्टी अगर पुरुषों के पास है तो बराबर कहाँ हो गए हम. There is a 10% gap in education. There are 3 judges in Supreme Court, women judges in Supreme Court. There are 11% judges in high courts. There are slightly higher number in the lower judiciary. You talk about women in managerial positions, about 3%. There are 1% women in boards. You look at any sphere. And this is not dependent on sex. Please try to understand. आप महिला पैदा हो गए इस पे डिपेंड नहीं करता है ये सब सोसाइटल नॉर्म से होता है. There's nothing biological about this. This is all gender. A gender is not men and women. Gender is what men and women do because they are men and women. So this is all changeable. और आप देख रहे होंगे पिछले कुछ सालों में बहुत फर्क आया है. There are women as fighter pilots. There are women who are in defense forces. There are women as locomotive drivers. There are women who are running tractor. ये कहने की तो मुझे आवश्यकता ही नहीं है. आप जितने भी लोग बैठे हैं वो अपनी माओं की तरफ देख के बता सकते हैं कि women are fully capable of running the households without us being there. आप लोग सभी घर से दूर होंगे, घर में काम चल रहा है, right? So there's absolutely nothing that women cannot do. So one, the stereotypes that Mrinal sir was talking about, let's break those stereotypes. Let's not put so much focus on women's body that उनकी इज्जत चली गई है तो अब उनका loss है. How many men have come back and told you कि मैंने rape किया? I know many women who have told me that they have been raped. Men don't talk about. How don't I know a single man who says मैंने rape किया है? आपको किसी को पता हो तो मुझे बताइएगा. मैं बहुत सारी महिलाओं को जानती हैं, और एक भी महिला जो यहाँ बैठी है अगर वो मुझे वाउच कर दे कि मेरे साथ ज़िंदगी में ऐसी कोई घटना नहीं हुई अनटुवर्ड, जो जिसने मुझे किसी ने गलती से छुआ ना हो गलत तरीके से, या मेरे को ऐसी बात ना कही हो. All of us have experiences like that. So let's also shift the language as judges, as duty bearers, as police officers, investigators, even revenue officers. Let's also start shifting the blame to somebody who has done the act rather than the person who has been violated. कहते एक दलित गर्ल वाज रेप्ड, आप रोजाना पेपर में पढ़ते होंगे, वहाँ फोकस दलित पे है कि वो इसलिए रेप हुई कि वो दलित थी. We say a higher caste man raped a woman. I think that will make more sense because जो activity है वो किसी और ने की है. So language really matters, particularly in judicial terms, language is very, very important, number one. Secondly, प्रॉपर्टी राइट्स की वजह से, क्योंकि महिलाओं के पास प्रॉपर्टी राइट्स नहीं हैं, even if there are property rights, women are not able to realize those rights because of social, cultural norms, because of their own lack of agency, because of their own support system that doesn't exist around them. They are not able to realize their rights. होता क्या है जब प्रॉपर्टी राइट्स हमारे पास नहीं है या हमारे पास कोलेटरल नहीं है कोई भी, उसका कॉन्सिक्वेंसेस क्या है? कॉन्सिक्वेंसेस ये हैं कि एज आई सेड, एज एन 8-year-old आई अंडरस्टूड कि मेरे पास कुछ भी नहीं है. तो अभाव का जो एक एहसास है वो हम सब महिलाओं को बराबर है. नंबर वन. सेकेंडली, इट्स अ मैटर ऑफ ह्यूमन राइट्स, एंड somebody is taking somebody else's rights, so वो भी एक वायलेशन है. दूसरी बात ये है कि महिलाओं को पढ़ाई से लेके उनकी फाइनल लाइवलीहुड तक के सवाल तक प्रॉपर्टी का मामला इम्पॉर्टेंट है. कि अगर मैं, जस्ट टू गिव यू एन एग्जाम्पल, इफ आई वांट टू स्टार्ट अ बिजनेस, आई वांट टू टेक अ लोन, जब मेरे नाम कुछ है ही नहीं, कुछ गिरवी रखने को, कोई पेपर देने को, कोई कोलेटरल के तौर पे, तो मैं कहाँ से लोन देगा मुझे? कोई देते ही नहीं है. एज अ रिजल्ट करीब 10-12-13% देश में विमेन एंटरप्रेन्योर्स हैं, बिकॉज एक्सेस टू फाइनेंस इज ऑल्सो डिपेंडेंट ऑन व्हाट यू ओन, एंड वी डोंट ओन एनीथिंग, सो दैट इम्पैक्ट्स आवर लाइव्स. द मैरिटल होम दैट वी से, अरे अगले घर में मिल जाएगा, इसका तो यहाँ क्या करना है, अगले घर में हो जाएगा. As a result, I was sharing during lunch time, we are permanent refugees. हम इस घर वाले बोलते हैं उनकी है, वो कहते हैं घर से क्या लाई है. तो हमारी कीमत सिर्फ इस पे डिपेंड करती है कि हमारे पास है क्या या हम लाए क्या हैं. There is no way a woman can go back to the house if something doesn't work out in the marital home, and it doesn't work out. 7 करोड़ लड़कियां आज के दिन by choice और by circumstances are single. 7 करोड़ मैरिजेबल एज की महिलाएं सिंगल हैं आज के दिन. What about their rights? मान लिया मेरे पास तो है हस्बैंड की प्रॉपर्टी, वो देना दे नाम से तो है, रह तो रही हूँ मैं घर में, बट आई एम सेइंग वो रहना होता है एक तो, और एक उसकी ओनरशिप होती है. एक है एक्सेस, एक है कंट्रोल. मुझे एक्सेस है उस घर में रहने का, लेकिन मैं ओन नहीं करती उस घर को. वो जब चाहे, जिस दिन खराब मूड में है, कह सकते हैं मेरे घर में रह रही, निकल यहाँ से. क्या ये सुना है कभी आप लोगों ने? नहीं सुना होगा तो सुनेंगे, बिकॉज आप जजेस हैं, आप लोग के सामने ऐसे केसेस आएंगे. ये बहुत बहुत कॉमन है, ये कह देना मेरे घर में रह रही है. सो वी हैव टू बी सेंसिटिव. अगर वो घर जॉइंट प्रॉपर्टी है तो कहना थोड़ा मुश्किल है. अगर मेरे नाम है तो वो कह देगा तो मैं अपने घर जा सकती हूँ, लेकिन ऐसा होता नहीं है. लेकिन सबसे ज़रूरी बात ये है कि अगर महिला के नाम पे प्रॉपर्टी नहीं है तो उसकी अगली जनरेशन को भी वो जो सेंस ऑफ लॉस जो होता है वो कंटिन्यू करता है, पर्टिकुलरली विद गर्ल्स. आपने देखा होगा डोमेस्टिक वायलेंस जिन घरों में होती हैं, उनके लड़के लड़कियों में 2 चीज़ें बहुत कॉमन है. यू जस्ट स्टार्ट नोटिसिंग, और एक पैटर्न है इसमें. लड़के बहुत वायलेंट हो जाते हैं. लड़कों को अपनी वाइफ पे हाथ उठा देना बहुत आसान लगता है अगर उसके फादर ने उसकी माँ को पीटा हुआ है तो. आप क्योंकि ऐसे काम में है तो आप देखिएगा ये बहुत एक पैटर्न है, बहुत ग्लोबली ये पैटर्न है. ये लड़कियां ऐसी जिनके घरों में वायलेंस हुई है, जिन्होंने अपनी माँ को पिटते देखा है, वो पिटाई को आसानी से स्वीकार कर लेती हैं और उसको चैलेंज नहीं करती हैं. सो वी नीड टू ब्रेक दो स्टीरियोटाइप्स एज वेल. और विदाउट प्रॉपर्टी राइट्स वो सब नहीं हो सकता है. सो मैं ये कह रही हूँ कि जो डिस्क्रिमिनेशन से लेके, ह्यूमन राइट्स से लेके, वुमेन को अपने फुल अदर राइट्स को एक्सेस करने के लिए या रिप्रोडक्टिव राइट्स को रियलाइज करने के लिए प्रॉपर्टी राइट्स का होना बेहद ज़रूरी है. ये क्यों नहीं होता है ऐसा? सब लोग बहुत आसानी से कह देते घर वाले नहीं देते, माँ ही बेटी का साथ नहीं देती है. कॉजेज सारे यही हैं कि हम सारे अपने मन में, all of us who are sitting here, with some exceptions, I can't give a sweeping statement, all of us believe that men and women are not equal, right? या कोई कहेगा कि नहीं मैं पूरी तरह विश्वास करता हूँ कि महिला और पुरुष बिल्कुल बराबर है। सो वही मैं कह रही एक्सेप्शन है, बट जनरली हमारे मन में ये आता है कि हम इक्वल नहीं हैं, लड़कियां कमज़ोर हैं, लड़के स्ट्रांग हैं, उनको प्रॉपर्टी राइट्स नहीं हैं, उनका यहाँ हक नहीं है इस घर में। ये सब हम लोग को बहुत बिना कुछ कहे हुए बहुत तरीके से सामाजिक तरीके से सिखा दिया जाता है। मैं हमेशा उसको बोलती हूँ कि इनसेंसिटिव होने की प्रॉपर ट्रेनिंग दी जाती है बिना कोई प्रॉपर ट्रेनिंग का फ्रेमवर्क हुए। सो इन बातों को हमको समझना होगा अपने डे टू डे लाइफ्स में। भाई अगर भाभी को मार रहा है, हम आसानी से उसको देख लेते हैं, हम खड़े होकर भाई को रोकते नहीं हैं। एक पुरुष अपनी वाइफ को सेक्स सिलेक्टिव अबॉर्शन के लिए पैसे दे के भेज देता और कहता है मुझे नहीं पता, मेरी माँ ले गई होगी। इफ़ यू टॉक टू अ मैन ही विल इजीली से मुझे तो मालूम नहीं, मेरी माँ ले गई होगी। भाई कैन शी गो एंड वॉच अ फिल्म इन रांची? नहीं। कैन शी गो टू हर मायके? नहीं। How can she pay 5,000 rupees and get a sex selective abortion done without your consent? And why couldn't you stop her? So my point here is that if men want, they can be a big support system for women to realize their property rights. They can say, मैंने किसी स्टेज पे अपनी लाइफ के ये क्लेम किया कि मैं अपनी ज़मीन नहीं दूंगी जो मेरे फादर ने मेरे लिए छोड़ी है, बिकॉज माई ब्रदर्स आर वेल ऑफ, दे डोंट नीड मनी, दे आर ऑल्सो सिटिंग आउटसाइड। ऐसे बेचोगे तो मेरे को भी पैसा कौन सा बुरा लगता है। एंड समबडी इन द फैमिली सेड लालच कर रही है। सो माई नेफ्यू हु लिव्स इन यूएस, ही सेड ममा, अपनी मदर को उन्होंने कहा कि तुम तो बुआ का राइट भी ले रही हो और मेरा भी ले रही हो, हमारा भी ले रही हो, तो भी लालची नहीं हो, और ये अपना मांग रही है तो ये लालची है, राइट? ये किस तरह का न्याय है? हमें नहीं चाहिए, जो इनका है उनको जाने दो। सो आई एम सेइंग इफ मेन वांट दे कैन स्टार्ट सेइंग दीज थिंग्स, इट इज ऑन यू। बट जैसे सर आपने कहा, वो उनको सूट करता है, वो नहीं कहते ये बात, क्योंकि उनकी अपनी जमीन में से कमी हो जाएगी ना। सो दे डोंट वांट टू से इट। सो माई अपील टू ऑल ऑफ यू, नॉट ओनली एज जजेस बट ऑल्सो as men, responsible men, to start supporting the rights of other family members, including your wives, including your sisters, including your bua or chachi or bhabhi or whosoever you think is in your area of influence. सरकार की बात है, बहुत सारे प्रो women legislations हम पिछले कुछ सालों से देख रहे हैं। मुझे नहीं लगता कि it is because of lack of legal support that we are not getting our rights. सरकार ने अपनी तरफ से, हम जैसे लोगों ने भी बहुत मेहनत की है सरकार तक बार बार तक एडवोकेसी करने की कि ये राइट चाहिए, ये चाहिए। सरकार ने बहुत कोशिश की है, they have really supported women. Now it is for us to start looking at how do we make it possible for women to claim those rights. So जब आपके पास एक केस आता है प्रॉपर्टी का, I wanted to tell you that it's very difficult for a woman to reach you. She must have thought 2,000 times before even going to the court. Again, because she doesn't have any property. उसके पास पैसा नहीं है in most cases, because that is the last resort for her. Because she is still expecting you to be giving her justice. और ऐसे में जो मैम ने बात कही थी जस्टिस नागरत्न ने, कि अगर वहाँ पे आपका एटीट्यूड उनके लिए ठीक नहीं है या एक भी डेरोगेटरी बात कह दी गई है, it will prevent 10 other women to start accessing justice, or it will discourage women to start accessing justice. So it's very critical that you are sensitive to those women who reach to you. चाहे बहुत मेहनत के बाद आप तक पहुँचेंगी वो, तब तक तो पहुँचने का इतना आसान भी नहीं है. Particularly police officials, if a woman has come to a police thana, there is no way she can go back to her household. तो उसने पूरी options को explore कर लिया है before she reached out to you. So be sensitive to her, please. हम सबका एक रोल है प्रॉपर्टी राइट्स को भी नहीं, सारे ही राइट्स को क्लेम करने में, महिलाओं की मदद करने में. All of us have a big role to play. एंड इतने सुबह से लीगल बातें कही गई हैं, प्रोविजंस की बात की गई हैं. आई डोंट वांट टू रिपीट एनी ऑफ दैट, आई डेयर नॉट डू दैट, बिकॉज आप लोग को तो सबको पता है ये सब, मुझसे बहुत कहीं ज़्यादा. सो आई वांटेड टू अपील टू यू दैट you in your capacity as a judicial officer or a police officer or a revenue officer have to play a proactive role in supporting women in accessing their rights. It's very critical not only for the women, but when women have money, studies show from across the globe that they spend that money for the betterment of the family. ऐसे बहुत एग्जाम्पल्स आप अपने घरों में देखते होंगे कि एक भाई ने शराब पी के सारी ज़मीन को बेच दिया, घर वाले देखते रह जाते हैं, कुछ कर नहीं सकते बिकॉज उसकी ज़मीन है, उसने बेच दिया, जबकि सिस्टर भूखी मर रही है, उसको देने को तैयार नहीं है. इतने सारे प्रॉब्लम्स हैं अपने घरों में, इतनी सारे पावर स्ट्रक्चर्स हैं घरों में, वी आर नॉट विलिंग टू सपोर्ट द गर्ल्स. सो the discrimination exists. I'm not saying don't look at your own daughters, because you are not discriminating against your daughters, you're providing them education, but thinking that it doesn't exist is also not normal. It exists because even today, as I said, 11% अगर property है दुनिया में महिलाओं के पास या इंडिया में महिलाओं के पास, तो discrimination तो है ही ना. And this is despite the fact that we have proactive legislations, a government has brought in legislations. दूसरी बात जो मैं, और वो अब मेरी आखिरी बात है ये, कि अगर हम intentionally inclusive नहीं हैं, intentional inclusive का मतलब ये है कि अगर हम सोच समझ के अपने बराबर लोगों को नहीं लाएंगे या उनको include नहीं करेंगे, including women in the property space, तो unintentionally हम exclusive हो जाएंगे. तो हम ना चाहते हुए भी, हमने सोचा नहीं ऐसा कि हम किसी को बाहर करेंगे, लेकिन हमें अब intentionally inclusive होने की आवश्यकता है. We as UN Women, we are working with a lot with private sector. We are working with all duty bearers, including police. In fact, I remember when I started, क्योंकि पुलिस केस ही दर्ज नहीं करती थी वायलेंस के, क्योंकि घर का मामला है, हो जाएगा, कोई बात नहीं, चले जाओ वापस. हमें ये लगता है कि जो कानून के कस्टोडियन हैं, उनको बहुत कानून की इंटरप्रिटेशन करने की आवश्यकता है, बजाय कि क्या उनके घर में गुजरी है उसके, या घर की शांति की जिम्मेदारी सिर्फ महिलाओं के ऊपर ना डाल के, क्योंकि all of us as citizens are looking up to you to support us. So my appeal to all of you once again is that whenever a woman approaches you for justice, please be patient in hearing her case and do what you can, and which is provide her justice. So thank you all very much. I'm really delighted to be here this afternoon.
A very good afternoon, all of you, honorable judges, ladies and gentlemen. The most tough task is of the last speaker, because everything has already been said. You are exhausted after the lunch, and everybody is on way to sleep. And as Dr. Keshav Raj said, we have a difficult task of keeping you awake. Anyway, thank you. Still, all of us are awake. The property rights of women, strengthening access to justice for women in India, is the topic which I have been asked to deal with. The subject, the first thing which came to my mind when this topic was given to me was, why this focus on property rights of women? Today from 10:30 I have been hearing about it, and in the recent past also the Supreme Court judgments, and there is general awareness now, and the focus is on exclusive property rights of women. So I remembered suddenly it came to my mind that the landlords, they were respected and revered because they were lords of the land. The Queen Elizabeth, she was the owner of almost 1/3 of the world's properties. The kings, they had huge territories. So property is a very important facet of personality. And the focus which has suddenly shifted in the last few decades on the property rights has long consequences, deep consequences. The significance of property was discussed by the Honorable Supreme Court by Justice K. Ramaswamy in the dissenting opinion in the case of Madhu Kishwar. Property is one of the important endowments or natural assets to accord opportunity, source to develop personality, to be independent, right to equal status and dignity of person. So the landlords were landlords because they had land. The king was the king because he had territories. The queen was the queen because she had the property of the whole world. And the woman had nothing because she was not powerful, so she was devoid of property. Land demands particular attention. It is the key to life with dignity and a basis for entitlements. These resources ensure that women are able to provide for their day-to-day needs and their families and to weather some of life's most difficult challenges. And the reason and the logic why property was kept away from women was because the gender disparities with regard to land and other productive resources are linked to the assumptions. The assumptions are important. That men as head of households control and manage land, implicitly reflecting ideas that women are capable of managing productive resources such as land effectively. Their productive resources given to women are lost to another family in the event of marriage, divorce, or male death, and of course, that men will provide for women's financial security. So there is no need why women should have got property. Dr. Rao has probably left. He was citing the example of Hindu law, that we are only talking about Hindu law. In the morning inaugural address of Honorable Madam Justice Nagratna, she had talked about Article 44 and Uniform Civil Code. Till the date we have an Uniform Civil Code, until that date we have a unified code governing property law in the entire nation. As a student of law, when I went through the different chapters of Hindu law from the 19th century to the 2005 amendment, I felt that the statement of Benjamin Cardozo, law is an instrument of social change. If we want to see the practical implementation of that statement, law is an instrument of social change, it is the Hindu law which has shown us that. And I have taken the case study of Hindu law in a nutshell to impress upon the legislative and the judicial reluctance which is still present in touching the customary law. The customary laws are different, diverse across the country. The religious laws are different, so we are not touching them. Yes, some laws say you get half, some laws say you get 1/3, some laws say you don't get. It is the custom, we will not touch it. It is the Hindu law which opened its arm wide to change, to take a volte-face from the patriarchal notions of property inheritance. And if you see this picture, this is in the year 2005, the tree is finally giving fruits. The earlier stages, the sapling era was the limited rights era, that is the early 19th century, 1937, the Stridhan era, which Dr. Rao dealt upon. Then came 1937, the Hindu Women's Right to Property Act. The substituted rights were given. Then came independence and came 1956, the absolute rights. And then, of course, the fruit-bearing era in which we are residing, and we are having the fruits of the law as an instrument of social change. It is the Hindu law which is shown the way. So I have chosen the case study of Hindu law. The reluctance which the judiciary as well as the legislature is still exhibiting in touching the customary laws for changing the notions of equality of shares for women, that has been done very successfully by the Hindu law, and therefore this example. Everything has been dealt in detail, and so this is the limited rights era, the Stridhan era, which Dr. Rao has discussed. So the picture I have cited specifically to show that this was the status then. You get something, he gets everything. The something you get is for your survival, for the usufruct purposes. You are not dying. You can maintain your living with that. That was the Stridhan era. So the beginnings were highly discouraging. We have already discussed that. Woman was something to be taken care of, a responsibility, a concern, and of course, when you have a responsibility and a concern, you don't give them property to take care of. Minors don't get property. Lunatic persons don't get property. So the woman who was a matter of concern, she was not getting property. This is, of course, early 19th century. Istridan, as the name suggests, it has been discussed in detail. I'll skip that part. Gifts given at the time of marriage. And it is also true that at no time the quantum of the property has been anything but meager. A very lion's share was the son's share, and the sparrow's existence was the daughter's or the female share, only for survival purposes. Then came the Hindu Law of Inheritance Amendment Act 1929. This was the first legislation brought by the British, and for the first time, son's daughter, and sisters were brought in the rank of heirs, but it was only for checking the role of survivorship, because in the Hindu way of life, the death of a co-partner, his interest merged with that of the surviving co-partners, and the female heirs, the deceased co-partners, were left on the mercy of the remaining co-partners. So the British thought that we should bring at least these three heirs in the first line. Then came the Hindu Women's Right to Property Act 1937. This was primarily aimed towards checking the plight of the Hindu widows. We have heard what was the condition of the widows in those days. They were either sent to Vrindavan or Varanasi, or they were dependent on the mercy of the surviving co-partner. So the woman was given ownership rights, but it was a very limited right. And as it has been explained in the case of Shatrughan Ishtar, the interest of the widow arises not by inheritance, not by survivorship, but by statutory substitution. Therefore, I have termed it as substitute rights. The rights of alienation are, however, restricted. She may alienate the corpus of the property only for the purpose of legal necessity or benefits of the state. Widow does not on that account become a co-partner. Though invested with the same interest which her husband had in property, she does not acquire the right which her husband could have exercised over the interest of other co-partners. She was put in the shoes of the husband only for her survivor. She was not allowed to alienate it only if it was only for the purposes of legal necessity or for the benefit of interest. And till her lifetime, the British had brought that act to give her the role of, give her the survival feat by giving this act. Of course, then came independence, and we had the Hindu Succession Act. And as this figure illustrates, it was for the first time that the he and she difference to some extent were done away with by the legislature, and absolute rights of property were given to women. This has been discussed in detail, so I'll skip that. But the important part was that for the first time after independence, the girl and the male child and the female child were considered humans who ought to get equal shares in property with absolute rights of alienation, which was still now only for survival. So now it was not a question of survival, it was a question of absolute rights with the right to alienate as per your choice. I want to give it to a trust, I can now give it to a trust. It's not necessary that I have to continue with it only for my survivalship. Interestingly, this 1956 right, which the Hindu Succession Act 1956 was challenged before the court. Section 14 was challenged. It was very strange because the society had got so used to the discrimination which was being meted out to the woman, and it was so systematic and deep that people were not ready to accept the fact that now women and men have got equal rights and absolute rights. So it was challenged, and Justice E.S. Venkatramaya's observation fortified women's right in the case of Pratap Singh versus Union of India. Section 14(1) of the Act was enacted to remedy to some extent the plight of a Hindu woman who could not claim absolute interest in the properties inherited by her from her husband, and the above provision is further protected. So Article 15(3) was taken aid of to justify the insertion of sections 14 and the Hindu Succession Act. So this was a very strange part of our society wherein the constitutionality of a provision was challenged, which welcomed the absolute rights of women. Then came, of course, 2005. Lot has been discussed. We get the co-partitionary rights in 2005, the Hindu Succession Amendment Act 2005. See, this act, this Amendment Act, is not only important because it gave co-partitionary rights to the female child. Now it has, now for the first time in the history of Hindu law, the difference between the XX chromosomes and the XY chromosomes was done away with. Just by virtue of being a girl, you were kept away from the ancestral property. Now, by virtue of taking birth as a female child, you are part of the co-partitionary. So the difference between 2005 Act and 1956 Act was that. The final finishing race was still some kilometers away, which distance was done in 2005. Now, women have been given the power to become Karta of the family. The concept of devolution of property by rule of survivorship was stopped. And of course, the recommendations of the Law Commission was taken into consideration because there was a whole lot of diversity in spite of the fact that 5 states had already come out with amendments in co-partitionary rights like Andhra Pradesh and Karnataka. But even then, the Law Commission had to recommend, and we had this doing away with the classic notion of co-partitionary. And now daughters were accepted as co-partners and were given the birthright in the ancestral property, which was missing till now. So after around 100 years, we managed to get the birthrights in the ancestral property, and therefore the Hindu law, which has opened its arms from total non-exclusion of its females to birthrights, is an example which the legislature and the judiciary can take to set the other customary laws which are prevalent and which are still not uniform in the matter of right to property of women. Now we come to the later part of this program, right to property of women, a tool for strengthening access to justice for women in India. This is the preamble to the Constitution of India. All the words are golden, but for the purposes of this conference, 2 lines are very important, therefore I have quoted. Justice and equality of status and opportunity. Justice in 3 forms: social, economic, political, and equality of status and opportunity. So the preambular goals, so far as today's conference are concerned, these are the 2 concerns. It's a very old African saying, land belongs to the man, the produce in it to the woman. If women do not have equal rights to property, what happens? With the man goes the land, and so goes the cultivation, and in comes hunger and poverty. The woman's right to property ensures access to justice in all forms, be it economic, social, and political. The economic facet already has been discussed by Madam and in different ways from the morning, but it's a very important facet of justice so far as women are concerned, because gender equality in property rights is critical not only as a human right issue, but also a key driver of overall economic development. Secure property rights ensures increased income, and when women's income goes up, the additional income goes directly to increasing household consumption and therefore into the overall economy. Most importantly, it ensures that women live life with dignity and not that of a destitute. In fact, the World Bank has coined the term gender equality as smart economics. And it proclaims that the economy has better opportunities to grow and is more resilient to crises if women and men have equal rights. Discriminatory laws and legal inequality leave the full economic potential of our global and national economies untapped. The social facet, very, very, very important. When women get property, they are no longer treated as property. Granting women equal property rights ensures decreased threat of discrimination, domestic violence, and other human rights violations. It gives them the much needed social impetus, bolsters their confidence, gives them a voice inside the household, as well as on social platforms, gives her the capabilities to say no to social evils like dowry and resistance to assault of any kind. The society starts looking up to a woman with property rights. As I said, the landlords and the kings and the queens. The daring activities of throwing out a woman in the middle of the night, calling her by names, the overpowering feeling of she being dependent on him for her life decreases. This is again, so secured landlines for women set off powerful continued ripple effects that go a long way towards realizing social equality and enforcing human rights. And the nutshell is a backbencher in social ladder is brought on the front bench. This is what happens when women are given property rights. The political facet, with economic stability comes the bargaining power. When women are given property rights, they are more adept at negotiating power in public and private domains. Now they are no more the recipients of policies, but actually have a seat at the policy-making table so that they can make the right policies on behalf of women and families. Increased inheritance rights gives women the much-needed voice, the authority to be a decision-maker with bargaining power, and the result is that in turn, female elected leaders increase women's capability to develop effective enforcement of economic rights via mobilizing political participation and women's social solidarity. Women as economic, social, and political actors can change policy choices and make institutions more representative of a range of voices. So this is the crux of today's conference. What happens when women get property? Women's right to property is directly related to the preambular goals of justice, economic, social, political, economic, financial security, and that leads to enhancements of social agency, and of course that leads to a political, say, increased leadership abilities. The way forward, the last part of my, see, these smiling women have registered deeds in their hands. So the way forward is that ownership rights for women, as Madam has said in the morning, that 30% reservation ought to be given. Some states have already done their bit. Delhi Development Authority is doing that. Our state also, stamp duty was earlier less for women. Many states are doing that. So ownership rights for women be encouraged by incentives offered at state and local government levels, including stamp duty for land registered jointly or in the name of women alone. So this is how ownership, there are many ways, by giving reservations, by giving ownership, by decrease of stamp duty, promoting joint ownerships. Now the thing is that what after that? Have we been able to actually get the fruits of women empowerment through getting property through women? See, the major part of the remaining challenge revolves around implementation and enforcement. Despite having good laws, women still do not enjoy their rights. Implementation is too often hindered by socio-cultural norms and women's lack of knowledge of their entitlements and men's lack of coming to terms with the fact that women ought to. See, 2005 amendment, many persons I know in my social circle who do not have any idea till date that now women have equal access to ancestral property, and they are equal shareholders to ancestral property. I know educated people around me who are not aware with the fact, very conveniently they say, ki, wo to hamari patric sampatti hai, this is for us only. The female do not. Female do not have because females do not know, and the men do not know that it is to be shared. So the major problem is, see, this is a very sad state. As I said, Andhra Pradesh was a state which had earlier given co-partnership rights to women. And even then there, the results were not very satisfying. So a research was conducted as to why this is happening. 38% of women in Godavari district, 12% of women in Krishna district reported considerations of family prestige, 27% in both these districts reported consideration of getting bad name among relatives and others for not taking resort to courts of law in getting their due share in property. Cost of litigation, complicated procedures of law, and uneconomic nature of the deals in terms of the cost involved in property are other reasons why this success has not been achieved. Now, it is important for both men and women, 50% men and 50% women. Women as important as men to be trained about gender issues relating to property, and in particular the males should be included in training to avoid marginalizing the gender issues as concerning only women. So let me tell you this August gathering that gender issue is not a issue concerning women only. It is concerning men also. So you have to be equal participant in understanding the impact. It is pertinent to change attitudes among both men and women as to the value of gender equality in access to property rights and how these changes can improve the economic and social well-being of populations. So public information campaigns like billboards, posters, pamphlets can be effective in spreading information and also in creating widespread understanding. Most important, that change is underway and that benefits that such change can bring. So you cannot go back and change the beginnings, but you can start where you are and change the ending. Legislature has done its bit, but here it's still stuck. It's not clear. It's not clear that now the shares, the rights of your sisters, your daughters, your wives, all the XX chromosomes with whom you live, they have equal shares. So it's high time that we talk about inheritance rights and do not talk about dowry at the time of marriage negotiations. Let us talk that this is the share of my daughter and this she will get. She will not get any dowry. Let us talk about equal shares, not favors. The brothers are not doing any favors by giving you the shares. And a daughter who claims rights in the property does not become a bad daughter. She does not become a bad daughter because she is claiming a right. She should not be given a choice to choose between the natal family and her rights vis-a-vis property. No, please don't do that. Please do not give her a choice because it is not her choice, it is her right now. She does not have to choose between the natal family and her rights. She has to get both. She should get her parents, she should get her brother, she should get her nephews, she should get her bhabis, the love, affection, as well as the rights in the ancestral property. And last but not least, let us not talk about women rights. Let us talk about human rights. These are basic human rights. Justice Chandrasekhar is not here. I take this opportunity to thank him for choosing this topic and also for giving us this opportunity to express our feelings. Thank you. Jai Hind.
Thank you, madams, for highlighting and reminding us all of the stark difference that exists on paper and in reality, and the ways in which all of us present here can make a difference. We have come to the end of the conference on Women's Right to Property, Road to Empowerment. Before we part our ways, I would like to sincerely thank our esteemed Chief Guest, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, Honorable Mr. Justice Aparesh Kumar Singh, Honorable Mr. Justice Sri Chandrasekhar, Honorable Mr. Justice Rangan Mukhopadhyay, and Honorable Mr. Justice Kailash Prasad Dev for gracing this occasion by their presence. Judicial Academy Jharkhand would especially like to extend gratitude to Honorable Mr. Justice Sri Chandrasekhar for his constant guidance and support to shape the conference. I thank all the honorable judges of High Court of Jharkhand and respected madams for taking out their time to attend this conference. I would further like to thank all our eminent resource persons, Honorable Mr. Justice Rajiv Sahai and Law, former judge, High Court of Delhi, Professor Dr. Kesava Rao Varakula, Vice Chancellor, NU Saril Ranchi, Professor Dr. Mrinal Satish, Professor of Law, NLSIU Bangalore, Ms. Kanta Singh, Deputy Country Representative, UN Women, India, Delhi, and Dr. Mrs. Vandana Singh, Advocate, High Court of Jharkhand, Ranchi, for enriching us with their knowledge. I also thank the delegates from bureaucracy, police, bar, and judiciary for participating in this conference. I would like to extend my sincere gratitude and regards to our Director Sir, Additional Director Sirs for their constant help and guidance towards designing the conference. I would also like to express my heartfelt gratitude to the District Administration Ranchi and the entire registry of the High Court of Jharkhand for assisting us in the organization of this conference. An event of this dimension would not have been possible without the support of the team of the very motivated and dedicated volunteers, section officers, research scholars, staff members of Judicial Academy Jharkhand, who worked tirelessly day and night to make this conference a reality. Last but not the least, I thank all the media personnel for giving this conference a huge media coverage. I wish you all a happy and safe journey. Explanations. Thank you. I request all the honorable judges with this spouses to please proceed towards the administrative. Kindly requested to assist. All the other participants are requested to proceed to Damodar Hostel for high tea. Thank you.